The board members that will hear your case tonight are as follows. My name is William Ray. I have the pleasure of being the chairperson of this group. To my right, we have Mr. Truslow, Mr. Brown, Mr. Sadal, and Mr. Neal. And to my left, we have Ms. Smith. Staff members present tonight that will hear our case is Ms. Sally Brooks, Ms. Clark, Mr. Foster, and Ms. White. And our attorney to my immediate right is Mr. Kevin Hugie. Because the hearing tonight is a public fact-finding meeting, we're in compliance with the Freedom of Information Act and South Carolina Code 6-29-70. 15 days prior to the hearing, an announcement was posted and printed in the Post and Courier. It was posted on or near the designated property. A notice was mailed to the applicant or the applicant's representative, to the property owners within 300 feet of the property, and to parties of interest. Persons, organizations, and news media have also requested declaration of our meeting and have also been notified. Board members, the meeting notes for December 2nd, 2024 were mailed to you. Are there any changes? If not, can I get a motion?
Second.
Can I get a second?
Second.
Who seconded it? Okay. All those in favor, please indicate by saying aye.
Aye.
All right. It carries. Thank you. Our case ruling from this and any other BZA meetings are available to the public for inspection during normal business hours at the Charleston County Zoning and Planning Department. The BZA is a quasi-judicial body that has final decision-making authority on the following: related administrative decisions. The BZA is authorized to hear and decide appeals only on zoning-related matters where it is alleged that there is an error in the order, requirement, decision, or determination made by the administrative official in the administration or enforcement of any zoning-related regulation. A 2/3 vote of quorum present tonight is required to overturn the decision of the planning director in an appeal. We also have special exceptions. A special exception is issued by the BZA authorizing a particular use in the specified zoning location and district upon demonstrating that such a use complies with all the conditions and standards specified in the Zoning and Land Development Regulation, also known as ZELDAR. The BZA must find that the special exception meet all 6 of the approval criteria in the ordinance in order to grant a special exception. A simple majority granted tonight is required for a special exception. And then we also have a variance. A variance is a relaxation of the BZA regulations of the ordinance where there is a such action that will not be contrary to the public interest and where, owing to conditions to the property, and will not result in the action or the situation of the applicant, a literal enforcement of the code that would result in the unnecessary and undue hardship of such variance, and is consistent with Section 6-29-800 of the Code of the State of South Carolina, Title 6, Chapter 29. The BZA must find that the variance meets all of the 7 approval criteria of the ordinance in order to grant a variance. A simple majority is required to grant a variance. Our purpose tonight is for interested parties to be heard in order to assist the board in gathering evidence that is pertinent to each case. If a board member of the BZA feels a need for further information to clarify a case, the board has the authority to subpoena witnesses. It is understood that the rules of your neighborhood or your subdivision are binding, and we can take no action that would neglect or overturn their jurisdiction on your property. In addition to your testimony, our board has been presented written documents and information submitted by staff, by the applicant, or the applicant's agent for each case. This information is now considered to be evidence and is entered into the permanent record of this body. It is assumed that it is complete, true, and accurate. This data has also been assembled by staff for the purpose to clarify the location and the application's effect on surrounding properties. Our board is empowered to approve with conditions, or to deny a special exception or variance request. We are also authorized to defer a case should there be a need to obtain additional information. The BZA's final decision will be mailed within 10 working days of this public hearing. It will be certified mail to the applicant and U.S. mail to the neighbors and the community of interest that is listed. If an applicant's request is approved, the applicant should contact the Charleston County Zoning and Planning Department staff to discuss the next steps in the process. Variances and special exceptions granted this night are also valid for 12 months during this meeting, and a one-year extension may be granted if only construction or development has been commenced or been diligently pursued. However, if an applicant's request is disapproved and the applicant wishes to appeal the decision of this board concerning the case, an appeal must be addressed by the circuit court. South Carolina Code 6-29-820 states that an appeal must be filed by the applicant within 30 days after the decision of this board, and it is mailed to them. Failure to file an appeal within that time limit deprives this board of the jurisdiction to hear a matter. Because this is a quasi-judicial body, everything in this meeting must be complete, true, and accurate. All the information provided to the BZA is considered evidence, and this board may certify contempt of circuit court if false statements are made either in writing or orally. Each person that wishes to speak or address this board will have to be sworn in by the BZA secretary before they can provide testimony or evidence. In order to expedite this procedure, those wishing to speak to this body, we ask that you stand as a group and the secretary will administer the oath. If you would, please stand at this time if you wish to speak.
Okay. So please stand, raise your right hand. I will say the oath and you will say, I do. I swear to tell the truth and nothing but the truth. I do.
Thank you. I will now call each case by case number. Staff will present facts that are pertinent to each case, limited to 5 minutes. I will then call the applicant. The applicant will state his or her name and current address for the record before presenting testimony that is pertinent to each case, limited to 5 minutes. I would then ask all those who are speaking either in support or opposition of each case, and they will follow the same procedure for identifying themselves and are limited to 2 minutes each. The applicant would then have a chance to reply to the opposition, limited to 2 minutes. And the BZA will make a motion to close the case to the public. Finally, the BZA will make a motion concerning the application stating specific facts of conclusion of law. Tonight, we have 10 cases, and we hope to go through them quickly, and we hope to give everybody a chance to be heard. For the benefit of you folks tonight, we have monitors that are here in front of us, so you won't typically catch us looking back behind us at the screens, okay? So at this time, I'd also like to take a moment to swear in our secretary. Our current secretary is out sick today, so at this time, Ms. Brooks, if you would, please stand. I gotta swear you in. So at this time, Ms. Brooks, do you swear to administer this meeting while we're here and present today? I do. Good. Thank you. Okay. The first case that we have tonight is case BZA 11-24-00819. And you will be taking that case for us tonight?
Yes, sir.
All
I will
right.
take the
Thank
first
you.
4 cases. For those of you who don't know me, I'm Andrea Melisick-White. I'm the Deputy Director for the department. So I'll be standing in for Jenny this evening.
Thank you.
Sure, thank you. All right, this is case BZA 11-24-00819. The applicant and property owner is Linda Toop. The location for the property is 652 Riley Road on James Island. Tax map number 340-0700-068. The zoning district is the R4 Low Density Residential Zoning District, and the request is a special exception request for the placement of a manufactured housing unit in the R4 zoning district. This slide shows the location of the property and the zoning of the property and the surrounding properties. As you can see, the property itself is zoned R4. It's surrounded by R4 zoning, and then in sort of the stipple color are properties in the city of Charleston. This is the section of our ordinance that applies to this particular request. Placement of a manufactured home in this zoning district is conditional if it's determined that the area within 300 feet of the property is characterized either entirely of manufactured housing units or a mixture of site-built and manufactured housing units. That percentage has to be 25%. In this case, there are no manufactured housing units, and therefore the special exception request is required. This map shows the properties that were included in the 300-foot notification. They are outlined in blue. Here is an aerial of the site and a little bit of a zoomed out aerial showing Riley Road and Central Park and the subject property. Staff conducted a site visit on December 12th of last year. This is a photo of the subject property and photos of 654 and 648 Riley Road, as well as of 650 and 658 Riley Road. And then finally, some photos of Riley Road itself. This is the site plan that's being proposed, showing the 16 by 76 square foot mobile home. It's about, calculated it, it's about 12,000 or 1,216 square feet in size. This is the plat for the property with the property starred. Staff did their review and found that the request meets criteria 3, 4, 5, and 6 and may meet criteria 1 and 2. The board may approve, or with conditions, or deny this request. If it's approved, staff recommends one condition, and that is that the manufactured housing unit comply with section 6.4.24.b of the ZLDR, which requires skirting and some other things. And that is the end of my presentation.
Very good. We have any questions? Yes, sir.
Thank you, Mr. Chair. Thank you, Ms. White. I have 2 quick questions. It looks like, can you go back to the site plan? Yeah, that one right there. So, at first glance, it looks like it's landlocked, but then it's the description of the property has 1A and 1B. Are these the same owners? I mean, a lot of these questions could probably be answered by the applicant when they come forward, but I'm looking for access. I'm trying to understand. I mean, it looks like it's landlocked, unless that's not Riley Road. Riley Road's out front, so I didn't know what was going on down the site. So let me just ask all my questions, and y'all can address them however. That's my first thing. Is it the same property that landlocked? And then I was asking, are there any other special exceptions granted in the area, not just the manufacturers? Is there anything else around it? 'Cause it looks like all the houses were regular houses.
They appear to be stick-built houses, and I don't recall any special exception requests because it is all residential in this area, so there likely wouldn't have been anything recent, at least. Yeah.
On the special exception, if the manufactured home is located by where they're putting in the diagram, that fits the setback requirements and all that good stuff, correct?
Yes, it will have to comply with setback requirements, yes, sir. And
Okay.
I'm trying to see.
Well, yes, I'm just really wondering about the access, and if we don't know, we can wait for the applicant, is fine.
Looks like this is an ingress-egress easement here that may be being used. Yeah. You see this? I'm sorry, you can't see.
Well, I can see it right here in front of me.
Yeah, there you go. Sorry, I was pointing to it. But yeah, the hatched area is a.
Is that for the lot, or for
That is
both
something that
lots, or?
We'll have to ask the applicant that question. But we will not issue a permit if there is not legal access for the property.
I'm fine, Mr. Chair. Thank you.
Thank you. Anyone else? Thank you, Ms. White. I appreciate it. Is the applicant present? Good afternoon. Please state your name and address for the record, and please tell us why we should approve your application.
Hi, my name is Linda Toop, and my address is 132 Kathleen Drive in East Stroudsburg, Pennsylvania. I would like to put a manufactured home on this property that I own.
Bring your
to
mic
have
a little
place-
closer to you so I can hear you a little bit better.
I would like to place a manufactured home on this property so I can have a place to call home in Charleston. Did you want me to answer the question you asked about the ingress?
You got 5 minutes. It's all yours.
Okay. The ingress egress I did pay for that to be added for my property to have entrance and exit off of that property. So that does belong to me
Okay.
on that property. That is some land that my mother wanted to build on. She wasn't able to do that. She had given it to her brother and sister so that they would be able to use it. My aunt graciously gave it back to me, and I would like to use it at this time to make her dream come true and mine at this time too.
Good. We have a special condition about skirting. Do you have a problem or issue with that?
None at all.
Did you go over that with our staff and review that?
None.
But you're aware of that, right?
Yes. You mean skirting on the manufactured?
Yes.
Yes. I went over that, actually, when I went to the manufactured home. They will be providing skirting for the home.
Okay. All right. You've already picked that out and have it.
Well, I have one in mind, if you so graciously say yes. And I would like to have a skirting on there, a very nice one.
That's good. I'm glad. That is a requirement. It's going to be a
Okay.
requirement. Okay. Is there anything else you'd like to say?
Please approve my right to have the manufactured home on this land.
All right.
And Happy New
That's
Year.
a good statement. Let me see if any board member has a question for you. Anyone on my right have a question for this young lady? You have a question?
I don't.
Well, we thank you so very much for coming and spending time with us today. Thank you for your time.
Thank you and Happy New Year.
Yes. Do we have anyone else to speak in favor of this application? Do we have anyone else to speak in favor of this application? Do we have anyone to speak in opposition of this application? Anyone to speak in opposition? Very good. This case is closed to the public. Board members, do we have any questions for staff regarding this case?
I don't.
Do we have any general discussion? Yes, sir.
I just want to reconfirm that the 25% requirement is met in this situation with regard to manufactured homes.
Is not a mixture. There are no mobile homes in the
mixture.
area, which,
Okay, so-
if there were, then we could have approved it as a staff level and you wouldn't have to see it. But since there aren't, they have to come to you.
But there
Yes,
are
sir.
none, so that's.
Correct.
Okay, thank you.
Mr. Truslow, you had a question?
No, I was prepared to make a motion.
Well, let's not hold you up.
We're not there
then.
yet.
Let's not hold you up. Okay. Well, go ahead. Let's move forward.
I'd be pleased to make a motion to approve the request in this case, the application that's been made. And since this is the first case of the year and this is the first case, I'm going to go into some details. We do this in every case, but I'll do it in the first one, and you'll know that the same thing's been done in every other case, even though we may not repeat all the terms. In case 11-24-00819, I move that we approve the application for a special exception for the placement of manufactured home in a low-density residential zoning district. The property is at 652 Riley Road in James Island. The tax map number is of record. This request is governed in general terms by the Charleston Zoning Land Development Regulations called ZELDR, Chapter 6, and in particular Article 6.1 and more specifically 6.1.2. It provides for the use requested. Notably, placement of a manufactured home and usage is subject to certain conditions. We talked about skirting, and they're contained in 6.4-24, which is a mouthful, but this is what governs the conditions here. all have been met. This is a mouthful, and I realize that, but we have stated what the law is and what we've reviewed and relied upon. As Mr. Seidel pointed out, there's typically a 25% ratio. Can have so many. This one doesn't have any, so there's within the scope of what might otherwise be required. You're well within that, so there's no reason to address that further. It meets the qualification, or the ratio in particular, for the number within 300 feet of this property, and we've had the benefit of the presentation that was well made, and thank you. We've reviewed all the various submissions, photographs, measurements, and the written and verbal explanations and those of staff. We've had the aerial maps, photographs, the radial maps, the contiguous properties that may be impacted and such. Notice, it's important that we have notice, and jurisdiction as proper as an attorney might say. It's proper here. The property is vacant lot, approximately 0.5 acres. The applicant has applied to have a manufactured home there, and the dimensions have been given to us, which are 16 feet by 76, properly sited, located on the property, appears quite reasonable. Property is bordered by multifamily apartments on one side, which is in the city, not within the county. There are 11 parcels that are within 300 feet, 7 of which are site-built homes. There are no manufactured homes within a radius of 300 feet, and hence the requirements have been met. There is a church within 300 feet. Given the fact that the site has technically manufactured homes are assessed within 300 feet, which has triggered this request and why we're here. The law allows this exception for this body to approve the request. The criteria set forth in ordinance section 3.6.5 have been met. I'd find that all 6 criteria have been met, and this is hence my motion to approve this request. The placement, number 1, is consistent with Charleston County's comprehensive plan, the primary goal of which is to provide affordable housing and have strategies for that and encourage people to do precisely what's being done under these circumstances. In fact, it's encouraged. There are 0 manufactured homes in this district within the radius in question. Hence, criteria 1 has been met. Number 2, the proposed home is compatible with existing housing in the vicinity, and it won't adversely affect anything. We've had the benefit, and thank you again, we've had the benefit of all you provide in a thorough investigation. I would also note that there's been no objection. Number 3, the setbacks, buffering, and such will be provided for. We have the site plan, and that's been made available to us. In this case, a 20-foot front setback, 5 feet on the sides, and 10 on the rear will all be met with the size of this mobile home, of this manufactured home. Number 4 fits in, given the siding and the features. Number 5, it's clearly within all of the law, as I understand it, regulations and standards is provided in section 6.425. And we've read all of these, and there are a lot of them. Number 6, the placement and site will not adversely affect traffic, nor safety, nor pedestrians in any way. So this is, again, compatible with everything that zoning seems to be provided for. So I've made this motion, provided the one condition required by section 6.2-24 shall be required. There's been an indication that the manufactured home people that are going to place the home on the site are going to take care of this, and it's just a technical. No, it's not a technical. It's a requirement that we have skirting on here, and that's to protect the community and you as well. So that's my motion.
All right, we have a
I don't think
second.
there's any more detail that needs to be provided.
You
Thank you.
nailed it.
No, can't be.
So
Second.
we have a motion that's been properly moved and second. Any questions? All those in favor, please indicate by saying aye. Raise your right hand.
Aye.
Aye. Any opposed? Very good, it carries. Where did she go? Okay, so congratulations. Your application has been approved. Within 10 working days, you'll be getting information from staff letting you know the next steps in the process. Thank you so very much for coming, and congratulations. Good night. All right, our next case will be done again by Ms. White. Our next case is BZA-11-24-00820.
Thank you. So the applicant for this case is Taylor Lentz of Travel Charleston. The owner is Matthew McDowell. It's located at 333 Curtis Avenue in St. Andrews, TMS number 350-09-00097. This property also is in the R4 zoning district. This is a special exception request to establish an extended home rental, short-term rental property in the R4 zoning district. In the applicant's letter of intent, they explain that they are proposing to use the property as a short-term rental for up to 144 days per year, which is the maximum allowed in the extended home rental category. The property offers up to 6 parking spots, 4 bedrooms will be rented, and the occupancy will be limited to a maximum of 8 guests at a time. And this setup is designed to ensure minimal impact on the neighborhood while providing comfortable accommodation for visitors. And just as a side note, remember that the board, if you approve this request, you may restrict the number of days that the short-term rental property may be rented in the aggregate during any calendar year, even though 144 is what is being requested. So this map shows the zoning, and the subject property is outlined in blue. As you can see, most of the area is either in the R4 zoning district or the gray stippled areas. Those are properties in the city of Charleston. And this area is mostly, if not all, single-family residential. These are the sections of the ordinance that apply to short-term rental properties. It's Article 6.8. This map shows the properties that were included in the 300-foot radius notification. All the properties outlined in blue received notices. Here's an aerial of the subject property. And then zooming out a bit of the bigger neighborhood. Staff conducted their site visit on December 12th. And here are some photos of the house from the street. And then looking along Curtis Avenue. And this is the site plan, and you can see the 6 parking spaces that are required are shown here in the driveway, and then in front of the house will be 2 of them. This is a tenant notice that the applicant proposes to include in the house that addresses things like trash collection, recycling collection, and will include the zoning permit number. This plat shows the location of the property. Staff found that all 3 of the special exception criteria for short-term rental properties have been met. The board, again, can approve with conditions, or deny this request. If the board approves it, the staff does have some recommendations for conditions to be included. They include, prior to zoning permit approval, the applicant must complete the short-term rental permit limited site plan review process. The use must comply with all requirements of Article 6.8. The property shall not be used as a short-term rental for more than 144 days in aggregate during any calendar year. And the property owner shall be responsible for ensuring that tenants comply with the Charleston County Noise Ordinance. Thank you.
All right, any questions of staff? Yes, sir, Mr. Neal.
Thank you, Mr. Chair. A few basic ones here. Is the applicant currently operating with a license for short-term rental property? Do we know?
I don't believe so, but we can ask the applicant that question if they have a limited home rental license. That would be the only type they would be able to have in this location.
Okay. Well, we would want, where I'm going with this is, are they operating it as with under the 144 days, with under the limits where they can do it, and then they're asking for it extended? So I'm trying to find out why they're asking for the 144-day rule.
Yeah.
And we've asked that, I thought we've asked that before.
Yeah. So in the R4 district, you can do what's called a limited home rental for up to 72 days per year without the special exception approval. I'm not sure if they have that permit or not.
Yeah, so
If
that's
they
the
don't,
question.
then they're operating outside the ordinance, of course.
Okay, so
Yes,
that's
sir.
the question I'll be asking then. And then, the number of parking spaces you said were 6 that are going to be on site. There's only 4 bedrooms. Is it 1.5? What's the rule and requirement for that?
So you have to have the number of spaces for the use, which in this case is 2, plus 1 for each bedroom, which takes them to the 6 since they're renting the 4 bedrooms. So that's how they got the 6 spaces.
So the 4 bedrooms plus the 2?
Yes, sir.
Is the 6, okay. All right, well, the rest of the questions I have will be for the applicant on property management and stuff. Thank you.
Yes. Mr. Brown?
Has the parking, I see spaces for 6 cars, but in looking at the picture, there was just one driveway. Are they planning on reworking the paving or designating parking areas, or was the plan just to park on the grass? Or
That would be a question for the applicant. We don't have any requirements for how that parking has to work, except it can't be on the street.
so you can park in the yard, I guess, is
Yes.
part of it if you want to. Okay.
Yes, sir.
Yes, sir.
Would you go back to the map that showed the county versus city jurisdiction? Why that's checkerboarded like that?
Our annexation laws in South Carolina allow that to happen, so.
So a single property surrounded by, could be city and the rest is county.
Yes, sir, as long as they could meet the annexation requirements to be annexed into the jurisdiction. Yes, sir.
Mr. Seidel, so as a property owner, you're allowed to opt, yeah, you can choose the city or the county.
I see. Thank you.
Any other questions? To my right. Ms. Smith? Thank you so very much, Ms. White. Is the applicant present tonight? Very good. Come on down. Please state your name for the application, name and address, and please tell us why we should approve your application, sir.
Yep. My name is Taylor Lentz, and I live at 1380 Florence Lane.
Thank you, sir.
So I am a property manager here in South Carolina. I've been doing it for about 4 years now. I've got about 10 clients. Matthew is one of my clients, or it's soon to be, hopefully. He lives in Colorado. He was renting this property out as a long-term rental, and it just wasn't going well for him. Tenants were kind of not treating the property very nice, and he ended up having to kick them out and redo the entire property. He probably spent close to $100,000 in renovation costs to redo it. I live probably like 5 minutes from this house, and he asked me if I can help him use this as a short-term rental. And since I do it pretty frequently, I'm used to all the laws, all the rules, all the permits. I said I would do it for him. I feel like it wouldn't be a problem for me to do it for him since I live so close by, and I've got tons of experience. So any questions you guys want to ask, feel free to ask.
Okay, I'll start off. So are you a licensed realtor?
No,
You're just a property?
just property management. yeah.
Okay, all right. And so you have your license with the state of South Carolina with
Yes,
that?
sir. Yeah.
It's going to come, and you know what, I won't steal it from my board members. Mr. Neal has a question for you.
How did you know, Mr. Chair?
I know where you're going. You've been on this board too long. I know where you're going to go with this.
Thank you, Mr. Chair. Mr. Lentz, so thank you for addressing my main question already, the proximity of property manager and stuff like that. So I won't go into all those details. But the question I did have was, is the owner planning on, how are they advertising? Are they advertising Airbnb? Are they using one of the platforms?
So I'll be advertising on their behalf. It'll be mainly on Airbnb and Vrbo.
Okay. And is there some type of compliance that you're putting on the website for noise and disruption? I mean, this is what we get from neighbors and stuff saying there's not a problem. And the reason I asked the first question is, was it currently being used as a short-term rental and it was successful and they wanted to go to the 144-day cap? Do we have any noise violations already? So that's kind of the process
Right.
I go through each time. So
Right. So it hasn't been used previously. It's a short-term rental. But there are houses in the same neighborhood that are being used. Me personally, I have a lot of precautions that I take to make sure that there's no issues like that. I can rattle some off if you want, but first of all, I make sure that I only approve guests that have previous reviews and that they're all 5-star reviews, so I don't take any bad guests. I've never had an issue with a bad guest before, or neighbors complaining, or cops involved at all. I also install, it's called a Minute. It's a noise monitoring system. It doesn't listen to audio, but it listens to like decibel readings.
Yeah,
so
we've
if it
heard
like,
that here before.
okay.
Yeah, no, that's good. That's good that you're doing.
Yeah, so
I'm fine. I mean, I don't have any more questions for it. He's fine with me.
Okay. Mr. Sadell?
Thank you, Mr. Lentz, for your testimony. Are you going to, there are the neighbors that surround this property, will you be giving them your name and number in case they have a problem with tenants so
Yeah.
that they can notify you?
Yeah. So Matthew used to live here in this house, so he knows a lot of the neighbors. He's built like friendships with all of them. So I can talk to him as well as reach out to them personally and obtain their contact info.
Well, provide them with your contact information. That's what.
Oh, yeah, both ways. Yeah.
All right.
Yeah.
That's the important thing. Okay, so you are planning to do that. Is
Yes.
that correct? All right. Thank you.
Mr. Brown, you had a question about parking? Right.
Same question before, but it sounds like it's been answered, so.
Well, I will ask. I will take that back. Do you have a question?
No, sir.
Talk to us about the parking. I noticed that this parking is kind of crammed in there, so I'm kind of leery about that. Tell us about how the schematics came up with the parking.
So, as you previously stated, the rules for
I understand the
Airbnb
rules, but
is
I'm looking at the flow of traffic.
Right.
How are you going to get these cars in and out? Because it doesn't flow to me.
right.
So
You're correct.
I'm
Yeah.
not really looking at 4 bedrooms here. I just think you're cramming them on here, to be honest. But I'm going to let you change my mind.
Yeah, so from my personal experience, there are never that many cars at a parking in a driveway. So this house has 4 bedrooms, which requires then 6 parking spots for them. Me personally, I don't think it's necessary, but if needed, you can always park in the grass. There's plenty of parking available. Obviously, you wouldn't be able to maneuver in and out easily, but if it came to it, yes, you could cram 6 cars in there. I don't think that is a reason to not approve an application, because I think at the very least, like, you're going to have like maybe a max like 3 cars for a 4-bedroom house.
Ms. White, could you pull up the photos of the front of the house, please? There you go. I can easily see, thank you. I can easily see where you can get 4 cars in there comfortably. But then you're parking on grass to get the other 2 in there.
Correct.
That doesn't always fly, okay? It would need to be in a different, I'm not trying to give you the answer, but you would need to do something differently for those other 2 cars than just park on the grass. Are you able to do something other than just have them park on the grass? Because otherwise we'll have everybody else just say, well, they just park on the grass. And then that would be a problem with the ordinance.
I could request that my guests maybe not drive a total of 6 cars and maybe try to compact to just 4 cars so they can all fit in the driveway.
Okay. That would take away one of your bedrooms. Okay?
Or I can request
I know
that
you're
they
going
maybe
on that.
park in a different area
Well,
or the side of the street.
Because you can't park on the street.
No, but the applicant was required to show parking sufficient for the number of spaces. Whether or not it's on the grass is really up to the applicant.
Okay. And it is also up to this board if we can require them to put some type of gravel or some type of surface to maintain that. So that's kind of where I was leading. I didn't want to give you that answer. But, Mr. Brown?
Well, now that I see it in a little bit bigger view, is there a drainage ditch running across the front of the property?
Yes, there is.
All right, so that does limit maneuvering to the driveway. There's no other way to cross over unless you were to,
Kind of pulling in first and then, yeah. It would require some maneuvering for sure.
yeah. I also happen to notice when looking here again that the two of the cars were half in the drive, or not half, but, partially in the driveway and partially in the grass according to the site plan. Was that drawn to a scale or just kind of a rough?
It was
drawing
kind of a rough sketch.
Okay.
So I guess my understanding is the property line doesn't extend the whole way out to the road, so part of the driveway is like not.
He's not talking
I meant
about
left
that.
to right.
Yeah, he's
Two
talking
cars
about the
parked-
width of
Yeah.
the driveway, not the part going out to the Curtis
See
Avenue.
the 9-foot width right there?
Oh.
That is off of the driveway, so that was leading my questions, but somebody said that you could park in the grass if wanted to, but, this goes back to where I was
Neal?
leading before.
Yeah, so I see where this is heading with a lot of us here. And, I mean, one of the criteria is that you're not going to change, adversely affect the general welfare of the community. And that's a test that we have to meet. There's only 3 tests that we have to meet to pass this. And normally these are very easy, but the problem here is that I see for my vote is you've got an enormous number of bedrooms, which is driving your parking requirements. Whether you're using all the parking or not is not a way to pass the test. So if the standard is you have 4 bedrooms, so you have to have 6 parking spots, and cramming 6 on a spot doesn't make it work. I don't actually like the fact that you can let them hang out to the street. They don't have to be on the property line, but that's what the code is. It's okay to do that. So really the problem here is that you've got 4 parking spots on a driveway that's only 17 feet wide, and you can't put 4, you can't go too wide without going into the yard, and then you got to put 2 more. So for me to get comfortable with this, and I'm just one vote, I don't know where the rest of the commissioners are, I would like to see some type of pullback on how many bedrooms, because then that would reduce your parking. So in its present state, it's hard for me to get past that one test. Now, I don't know how the other commissioners are. Mm-hmm. So your options are, you're fine with 3 bedrooms instead of 4 bedrooms, or whatever it takes, and we can't sit here and design your project for you. So although I don't like to defer projects, deferral might be a solution here to come back with a different animal, or you'll have an up and down vote tonight. So I'm just telling you the process that we're going through. But right now, based on this schematic, it's going to be hard for me to support this, because I think you're going to affect the community with the way the parking is. Mm-hmm. And because once we start looking at parking, we don't care if you park in the front of the house or back of the house. Mm-hmm. If we could allow you to park on the street, it'd be no big deal. But what's driving it is the number of bedrooms for this house. So I don't know how you want to respond, but that's the elephant in the room right now.
Well, I guess 2 thoughts that come to mind.
And you have the power to ask for a deferral. Obviously, we can vote one, but if you defer one, if you request a deferral, it makes it a lot easier a lot of times. Just throwing that out there.
Sorry, what is a deferral? What do you mean by that?
Mr. Chair, you want to?
So deferral allows you the opportunity to go back and punt instead of trying to get the touchdown, in other words, in football analogy. So it gives you an opportunity to reconsider some of the things that you've heard here tonight, change your plans, and then bring them back before.
Okay.
That's a deferral. You could also, just like he said, you can move forward with what you have, present it to us, and we can vote on it. Mm-hmm. It may or may not pass. If it fails, then you have to wait 12 months before you can come before this board again, if it fails, okay? Now,
Mr. Chair, point of reference with 6 people, he needs 4 votes to pass, right?
So the other thing that could possibly happen, if that a board member would make a motion to approve, but only approve maybe 3 bedrooms rather than 4, and you accept something to that magnitude, and maybe you could come back
I'm giving in my answers. And improve what you have and come back. That way you won't have to be.
Well, I love the idea of just adding some gravel to help, add to the driveway. I think that's probably the easiest solution that would be a win-win for both of us. I think either that or maybe ask my guests to only bring 4 cars, which I'm not sure what you all would think about that, but.
That kind of all depends on who makes that motion to approve or disapprove, or to approve with conditions. That's kind of what we're looking at. But right now, you have the opportunity, I'll come to you, Mr. Brown, you have an opportunity to ask for a deferral. But before we get there, I'm going to let Mr. Brown ask a question of you at this time. Mr. Brown?
I got a question for you, and then also maybe for you,
Mr. Hughie?
Mr. Hughie. Do we have the ability to limit, based on his ads or whatever on Airbnb, the number of cars that people can drive here? Let's say he says, we can only have 4 cars, you can't drive more than 4 cars, but they show up with 5. Does what we have and putting conditions on here give us the ability to do that, or is that just a...
The number of parking spaces are driven by the number of rooms. So that's really what determines.
That's the only thing that can be adjusted. So whether he says it or not in an ad does not...
I'm sorry, what he says?
If he, in the advertisement on Airbnb, even if he says you can only have 4 cars here, there really is no hard rule that we can establish to limit that.
Well, we can't police it, but there's a mechanism where the county does checks on the actual advertisements. So if they find something that's in violation, he'll get a visitor.
But you see what I'm asking, I guess, is can we limit the number of cars parking, even though...
You can limit the number of rooms.
Based on the rooms, okay.
Yeah.
That's my question for you. Do you know if...
Mr. Brown, speaking to the microphone so everybody can hear you.
Do you know if the owner would be willing to go with 3 bedrooms at this time, or is that something you need to ask them?
I think would be fine if that would mean your approval, yeah.
Well, I apologize, but the board is giving you their observation. Whether or not they approve, that will come during the vote. And just to clarify, if you defer, you will get on the agenda within the next 90 days.
Okay. So one more thing, I guess, to add. Like I kind of mentioned earlier, my clients live in Colorado. They put a lot of time and money into this property, and they're looking to get a return on their investment, and they're looking at me to help them.
So just to clarify, the board does not take into effect financial considerations, so it's not.
That's perfectly fine. I understand that. It's in my best interest to help them get up and running as soon as possible. So I feel that I should not defer and try to get this pushed through to help them.
Mr. Chair, may I ask a friendly question?
That would probably help him.
That may help us to help you. Where we stand right now, as I understand it, you can't commit on behalf of the owner to a deferral. With a deferral, you would be back here in generally 30 to 60 days. Our next meeting or the meeting after.
It would probably around 90 days.
90 days, and if you got the approval of the owner, then to limit this to 4 parking spaces, that would make a lot easier for us. Would you be willing to ask for a deferral, or do you want us to vote today? If you vote today, there's a vote today and it doesn't work in we're driven by 4 bedrooms, which means 6 spaces, but if you're not successful, then they're out of luck for a year. And right now, what I'm hearing, you tell me if I'm wrong, what I'm hearing is you can't commit for the owner today, but you could, we could do it one of 2 ways, using a legal term, nunc pro tunc, later for now. If we could approve, we could approve if you would come back and tell us you got approval to limit to 4 parking spaces, which is an alternative. Where do you want to go? I'm trying to help you we're trying to help you get to yes, but we got some problems. Even though when I look at the aerials, I see one car parked out by the street and 2 houses away, a sailboat. It looks like a sailboat that's parked in the front yard, not in the front yard, contiguous to the street.
Procedural question.
So, do you want a deferral, or do you want us to vote, or can you commit, or you would ask us to?
So before you answer that,
Subject.
I'm going to try to speed this along. But before you do that, let's try to wrap this up. I'm going to give you a chance to ask that question for
Yeah,
Mr.
I have a
Huger.
procedural question, and that is, we're hearing this tonight, and there are 6 commissioners here, which for a positive vote will require 4 positive. So if it was deferred and it comes back in 60 or 90 days, and if the board is at full, at 9 commissioners or 8 or 9, will all 8 or 9 be able to hear even though it was deferred, or is it just people that was opened today?
It's
All of the board members, if it's deferred.
Okay, so you'd have more commissioners here likely in 60 or 90 days, because normally we have 7 or 8 or 9. Can't guarantee it, but if you have 9 here, then it takes 5, but you've got more room for error. So that's the procedure that you would go through, being able to answer more questions, follow up with things. So I just wanted to make sure you understood that type of procedure. Thank you, Mr. Chair.
Thank you. So at this time, you have an opportunity to kind of tell us if you'd like us to move forward or not.
Is there one more alternative? Could we just hit the pause button and let him go make a phone call, perhaps? See if there was a commitment to.
Well, the applicant had an opportunity to be here, to be present, and he is representing the applicant.
All right.
So he's got all 7 shots. So,
I mean, just from hearing you all talk, it sounds like you are all leaning towards deferral. So it sounds like I should maybe go back and rethink things and come back to you again. It's not in the best interest of my clients, but I think it's probably the best move to make. I guess I could use some guidance on like what to do differently.
that's the beauty of having the staff that we have here.
Okay.
They're not going to want to, they will help you, and you have the best help whatsoever by doing that. So if you're requesting a referral, yes? Okay.
Yes.
So we have to have a motion to accept the referral and vote on it from that point. So board members, we have a request for a referral. Do we have a,
I think it's appropriate to get on the record that the applicant needs to
Request it.
verbally request the deferral.
Thank you.
If he wants. if he wishes.
I'm requesting a deferral.
Thank you.
I'll make a motion to defer case, BZA 11-24-00820 at the request of the applicant for deferral of this project. Do I need to give reasons?
No.
Okay.
Do I have a second?
Second.
Okay, we have a motion that's been properly moved and second. Any question, discussion? All those in favor, please indicate by saying aye and raise your right hand.
Parking.
Aye. It is unanimous. So, sir, within 90 days, this wonderful board staff will reach out to you and get in contact with you and let you know the next steps in the process, okay? But please be diligent and work with them and try to figure out ways in which you can get your agenda moved forward, okay?
I think he needs to reach out to the staff. Their job is not to reach out to him.
Your job is to reach out to staff. I said it wrong. Thank you. That's why we have this brilliant man here. You're to reach out to staff, okay?
Okay.
All right? Thank you so very much for your time tonight.
Thank you.
Good.
Parking in bed.
All right. Thank you. So our next case will be done by Ms. White again. Case BZA 11-24-00821.
Yes, thank you. So the applicant and property owner for this case is Maurice Reed. The property is located at 2007 Sireford Court in the St. Andrews area. The TMS is 286-13-00-376. It is in the Hunt Club Plan Development Zoning District. And it is a request for a variance to reduce the required 25-foot rear/freshwater wetland setback by 5.5 feet to 19.5 feet at the closest point for a proposed deck and patio at the subject property. And as I said, the subject property and the adjacent properties, subject properties shown here, highlighted in blue on this blue map, they are all within the Hunt Club Plan Development Zoning District. And the subject property is a little over 1/4 acre in size, and it contains a single-family residence that was constructed in 2020 based on Charleston County records. These are the sections of the ordinance on the left that allows properties within individual lots within plan development zoning districts to request things like variances to the Board of Zoning Appeals. It used to be required that they had to go through the whole amendment process for plan development zoning districts. And then on the right, you can see a page from the Hunt Club Plan Development, and highlighted about midway down that page is the requirement for that 25-foot setback. The subject property is shown here in highlights, and the other properties that are outlined in blue are those that received notices in our 300-foot notification process. This is an aerial view of the subject property. You can see the wetland behind it, and it's a freshwater wetland, not brackish. This is a zoomed out aerial of the subject property and the surrounding area. Staff conducted the site visit on December 12th, at which time we placed the sign on the property. Here are some views of the subject property. And these are photographs that have been provided by the applicant. You're looking at the rear of the house, and then the yard going into the freshwater wetland. And again, just from the other side of the house, looking at the rear. And looking towards the wetland. This is a survey of the subject property. And this is their site plan showing the rear of the house and the proposed deck and patio with the wetland buffer boundary running through it. It's that orange dashed line. Okay. This plat includes the subject property at the top left, the starred property. And for the variance approval criteria, staff found that the request may meet criteria 1, 2, 3, 4, 6, and 7, and it meets criterion 5. And if the board chooses to approve this request, staff suggests a condition be included stating that the encroachment area shall be limited to the footprint that is shown on the submitted site plan. Thank you.
Yes, sir, Mr. Siddell.
There's a POA in this Hunt Club
Yes, sir.
development. And did I understand that they have approved this variant? They have a requirement of a 25-foot setback as part of the POA, and they've approved an exception in this case for this property?
I don't know that the answer to that. That would be a question
Okay.
for the applicant, but the applicant did sign the restricted covenants affidavit stating this would not be in conflict with their bylaws asking for this variance.
Okay, so I'll ask that for the
Yes, sir.
the applicant then. Thank you.
Anybody else have a question for Ms. White?
If I could, I wanted to follow up on that, and I thought you did a very good job making your presentation in the documents you provided. Stated another way, I would ask the question of what do the PD documents say regarding this? And I say that what I'm reading is it says that for this to be granted as a threshold matter before we get to the criteria, that it requires an amendment to the plan development that's processed following the procedures prescribed by Charleston County. In what I've looked at, and I don't see that in my documents. Is that a question we should ask the applicant, or do you know the answer whether there's been an amendment to their PD? Typically, when you have a PD, it's so you can cram in more in less space. And if my major concern is if we granted this for one, it appears to me that it's potential for a lot of problems, because then it would apply to everybody and defeat the whole reason for zoning. Do you have any document, or is that something I should ask?
So the plan development itself has not been amended for this particular purpose.
Okay.
They are asking for a variance from this requirement, setback requirement in the plan development document. It used to be until about 2021, if you wanted to do something like this, we would require you to go through the whole plan development amendment process. But we changed that requirement and will now allow variance requests on individual lots, even if you are in a plan development. So that's why these folks are here. They're requesting that relief.
Anyone else have a question for Ms. White? Thank you so very much.
Yes, sir.
Is the applicant present? I am. All right, Mr. Reed.
Yes, my name is Maurice Reed.
So, thank you, Mr. Reed. Hold on. You came in late, Mr. Reed, so you were not sworn in. Okay?
Yes.
So at this time, Ms. Brooks, if you would, or Ms. White, whichever, someone needs to swear you in.
She's got the script, so she's sad to do it.
It's just a procedure we have to go through.
Okay, raise your right hand. Raise your right hand. I will say the oath, and you will say, I do. I swear to tell the truth and nothing but the truth.
I do.
Thank you.
All right. Thank you, Mr. Reed. So if you would, please state your full name and address for the record, and please tell us why we should approve your application, sir.
My name is Maurice Reed. My address is 2007 Seifert Court in Charleston, 29414. The reason and purpose of my application is to install a deck that is large enough that we could enjoy the property that we purchased, and the deck itself is really an elevated deck, so the foundations of which would be minimally on the edge of the buffer zone, and the patio, which would be just a ground structure and patio brick, would be level and not impact water retention or drainage on the property into the watershed at all. And so the purpose of my application is really just to make the home even more enjoyable as we go forward into my retirement years.
Okay. Very good. Let's see if any board members have any questions of you. I'm going to start on this side. Ms. Smith, you have any questions?
I don't at this time.
Okay. I'm not going to start with Mr. Neal. He always has a question to start off first. So, Mr. Siddell, let you go first.
Mr. Reed, thank you for your explanation. For the Hunt Club, do they have a setback requirement as part of their POA requirements for homes?
To my knowledge, no, but I know that the manager of the property has said that once I go through this process, then I go through the HOA approval process. And so the stipulations that they will have, I've not yet to encounter, but the project manager has been apprised of the plan and is aware of my application and has not given me any indication that there would be any problems taking this forward, nor have any of my neighbors.
Okay, so as far as you know, there are no requirements, setback requirements set by the Property Owners Association?
Not to my knowledge, not beyond what's on the plat, on the drawing.
Okay. The jurisdiction is the POA first. I mean, if POA has requirements, then
When
we
you say
cannot,
POA,
we cannot
would you-
grant you a variance that goes beyond what the POA variance.
I'm not
Yeah.
sure what the definition
Well,
of POA is.
Okay, for clarification, I think there's, so some communities call them homeowners associations, some are property owner associations, same thing.
Okay.
The language, he didn't
I'm
understand.
sorry,
the language.
HOA, maybe
Right,
that's
thank you.
more familiar. Yeah.
So your question, sir, again is?
HOA has primary jurisdiction. We can't give you a variance that is outside of what the POA requires unless we have something, you have something that says that you're released from that.
The way they explain the process to me is that I have to get the variance first, and then once I get that, I present that to the HOA, with an application that is similar, although a little bit less detailed than the application I applied here. And then after that, I come back to get the plans approved.
Okay.
Mr. Neal?
Mr. Sardell? You'll follow up? Go ahead.
No, go ahead. No.
Follow up, I'm sorry, I thought you were finished. I apologize.
I- If they come back and say that they don't agree, then they can just tell you no, right?
I was under the impression that you would give me your opinion, yes or no. If you said no, I wouldn't even go to the HOA. If you say yes, then the next step for me would be to fill out the application for the HOA and get that approved, and then go to the planning department to get the plans approved.
Okay.
I mean, are there
Hang on.
are there notices or descriptions in here of what we can and can't do, and where this it says a increase in setbacks is a minor modification, which is allowed in PD development plans and that kind of thing?
Speak a little louder, Mr. Brown, and into the mic.
Mr.
So
Brown.
that's questions for the staff and the attorney that we hash out. But that's a good question. Please hold that thought. Mr. Neal.
Thank you, Mr. Chair.
We'll address that question, Mr. Brown.
So the easier process, even though your property manager for your homeowners association has said, hey, go to the county first and see if the county gives it to you, and then after that we'll go. It really is easier if you go to the homeowners association first, see if they'll approve. I'm sorry, it's just easier from our end because we're restricted in a box of what we can approve. And what it looks like is that the homeowners association documents have rules and regulations, and they're going to have to give you a waiver to get around that as well. So right now, it's going to be hard for my one vote to support doing what you want to do because there's that cloud up there. Is the homeowners association going to do this or not? Because what we don't want to do is approve something and then they come back in and say, no, you can't do it. And here we have done this whole process when we didn't need to do it anyway because the HOA wasn't going to approve it. So that's just how I've seen it work. It's the chicken and the egg. Which one came first?
So
it's a lot easier for the homeowners association. But my question really for the applicant on this design is there any other design that you have? Because it just looks like you wanted to square off the deck and square off the patio, and the deck is not protruding into the setback area as much as the patio is. Is there something, I can't really tell if this wraps around the house or just the rear of the house. It seems like it could go a little bit more to the left and have a longer deck and not be protruding into the area. So I was wondering, did you look at any other scenarios for this, or did you just square it off because that's what you wanted to do?
I just squared it off. It wasn't an intentional design for squaring. I'm not wedded to that. The desire was to have a deck, and because of some of the other existing HOA rules that I know exist, I didn't want anything visible from the street.
Right, and I understand.
So that was the objective, and that adds to the privacy, even though the neighbors to my right as you're facing the house can't see in the backyard, and the neighbor from the left can't see much into the
Right,
yard.
and I understand that. And again, that kind of goes to where I'm driving this. It really helps a lot of times to do the homeowners association approval. Even if they steadfast say, hey, we're not going to give you approval until you get to county. If you got a letter from them, something that says, this is the process we're going to be going through. We have no objection to this right now, but we need to have county approval first, and then it will be a rubber stamp of whatever it's doing. So I think everybody's probably thinking we're going to defer every project tonight. This is one that fits in that category if you choose to or want us to, because it would give us more information that we would use to process some type of approval. I'm stuck on, I think you're going too far into the setback for no real reason other than you just want to square it off. I agree that you don't want to see it from the road and stuff like that. Those are all valid concerns that make sense to me. But there seems to be a lot of other things out there now that are going to be red flags or question marks that we can't nail down tonight. So that's just where I stand right now. Thank you, Mr. Chair.
Okay, so thank you. If I could, Ms. White, I'm going to put her on the spot.
Yes.
So there is a point of clarity that
you could probably bring to this board, I'd greatly appreciate it if you would at this time.
Okay, yes. So I just want to make sure that I was clear when I was presenting these two documents. So the document on the left here, this is from our ZLDR. It's in the plan development section. And it references this section down here, variances. That variances, Article 3.10 of ZLDR relating to variances shall apply to all approved plan development plans, even those that were approved like Hunt Club before this section came into existence, with respect to zoning-related dimensional design or performance standards on individual lots, meaning they can ask for setbacks from plan development zoning districts. And so this page on the right, which is from the Hunt Club Plan Development, which is not a POA document or an HOA document. That's the county zoning for that property. That plan development document was developed by the applicant at the time. They wrote the zoning. They asked county council to adopt it. County council adopted it. And these are the setbacks. So it's just like any other zoning district. It just happens to be a plan development because, like was said earlier, they wanted something different than what the zoning allowed at the time. So they're asking for a variance from the 25-foot setback that the county has. Does that make sense?
This is not a POA document, a HOA
No, sir.
POA document.
No, sir.
That's different now and then.
Yeah.
That's different.
That clear the mud for you? It doesn't clear the mud for you?
Well, I'm looking at section 4.25.10, and it talks about, this is not a minor modification. This would be, by definition, be defined as a major modification. And it says, any modification not considered minor is major. A major modification requires amendment to the PD development plan in accordance with procedure specified in this article. That's my problem. My heart is with the applicant, but my brain's trying to follow the law. And I'm echoing from another perspective what Mr. Neal said about that the applicant might be better off. We don't like necessarily to defer things because we'd like to give you some resolution as quick as we can. This is a situation, classic situation, we might be better off making sure that your PD, not architectural review board, but your PD finds this to be acceptable.
Ms. White?
Okay.
Yes. So
In that
just to-
context, would you be in favor of a deferral, or you want to?
Hold on, Mr. Trullo.
So the section that you were referencing, the minor modifications and major modifications, so those have to do with if somebody came in and said, okay, this is the 25-foot setback for all the properties in the planned development district. I want to take that down to whatever, 19 and a half feet for all the properties. Those two sections are geared towards if you want to make a change that affects the entire zoning district. Section C, variances, is not a minor modification or a major modification. It's just a request for a variance on an individual lot. Does that make sense?
Right.
They're sort of different categories.
More or less in for relief.
Yes, sir.
Individualized.
Correct. On an individual lot, not affecting the greater
Right,
district.
not all of them.
Yes, sir.
That's a good observation, gentlemen. Good observation.
Well, under variance, it says that all except for minor modifications, and there's a definition, it requires an amendment to the PD development plan. So for a different reason, I concur with Mr. Neal.
But it's not for all the lots, it's just for this
Yeah.
one. That's why it would be minor.
Yes.
You see all the fun we're having with you, Mr. Reed, today?
It's supposed to be an easy.
We want to help you if we can.
So the question was, Mr. Reed, based on your drawings and your plans that you have, Mr. Neal asked, and you stated you were just trying to square it off. Do you have any other drawings that you could use that would work within the parameters of the setback? Because I notice it is kind of slanted there. But
Right.
if you wanted to square it off, could you?
At the closest point, as I read the plat, the setback or the buffer zone begins 6 feet, roughly 5.9 feet from the back corner of the, that would be the northeast corner of the house. And that would be really too small to be usable for what our purposes would be. And, being elevated on the other side where there is a little bit more room also gives us a perch to observe into the wetland buffer zone, because there is some interesting sounds that we hear at night that we'd like to kind of determine what makes them. Not being someone from the Low Country originally. So, I think in some form or fashion, I would like to have a permission to utilize some of the area in that buffer zone, recognizing that of the property, I'm really looking at taking advantage or using less than 5% of what my buffer zone is, and recognizing that I know a number of my neighbors have done things similarly in various forms or fashion that allow them to take advantage of the area as well.
Rightfully so. Let me ask you a question, Mr. Reed. Without me having to look back, you see in the green you have the patio area, and then you have the dotted line.
Yes.
And then you have the deck. That dotted line next to the deck and the patio where they meet, how many feet is it roughly? Is it from that dotted line to the very edge of the deck? How many feet would you speculate that would be?
From the dotted line to the edge of the deck, I would guess is...
So that's 12 feet. Is that like half? It's like 4 feet?
I would say 3 or 4, without taking a rule to it.
Okay. 4 feet. That's what I was thinking. Yes, sir.
Yeah, I had one more, I had actually 2 more questions. The first was more threshold, was relating to a deferral, if that's something that you wanted us to entertain. The second thing was, and I'm just trying to, I told you where my heart lies, but I also have to try to, as best I can, to comply with the law. Under criteria number 3, it requires you would be prohibited from using your property or unreasonably restricting the utilization of your property. Is that what are you telling that's what's that's what will happen? You won't be able to utilize your property, or it'll be unreasonably restricted?
We wouldn't be able to have a deck if there's not enough space to make it worthwhile to use. I wouldn't construct it.
Then the second part of that was, you mentioned that other people had done something similar. Do you have any supporting
I
documentation?
have no documents, and will
Okay.
not, and they've done things in different ways, as far as making use of the wetlands or clearing parts of it or doing other things. But I feel, or I felt it obligated that if I'm going to have plans, that I want them approved and sanctioned by all of the various bodies that need to sanction them.
You're going about this the right way. I'm just, but we can't prosecute your case on your behalf. So I'm asking these questions, and
Right.
that brings me back full circle to the deferral, I suppose.
All right. Let's see. Mr. Brown, let's go to you. I saw your hand first, Mr. Neal, but let me go to our new member, Mr.
I
Brown.
had a question for staff. What's the rule with the setback as far as, is it something on the ground within the setback, or is it like a plane going up in
Hangover
the
as
air
well.
and nothing can go beyond that at all.
Setback is setback.
Yeah, the setback, you can't have, structures in the setback. You can have drives and things like that, and we can grant certain administrative relief, but this is beyond what we can grant.
But okay, I just
Yeah.
mean like,
Yeah.
you can't have a surface not touching the ground, but hanging out
Correct.
over the setback.
Still a
It's
structure
straight
because it's
plane.
in the ground, yeah. Mhm.
Mis-
At some point, it's anchored to the ground. Yeah, but I see where you're going. Yeah. So in this case, he does need the variance for this particular.
Even if something was only hanging over the ground and then found the supports were inside of the setback.
Yes, sir. Yep.
His architectural mind is coming into play now. The overhang.
Yeah.
I can see the wheels turning. Mr. Neal?
Yeah, thank you, Mr. Chair. So I'm not sure if you're aware, if the applicant's aware, but the criteria that we have to meet to grant a variance are 7 terms. I won't read them all out, but the one that is the hardest mountain to climb is number 6, and that is the need for the variance is not the result of the applicant's own actions. In other words, are you submitting something that you want to build that makes us break the rules? And then you're asking us to break the rules, and we come up with a reason to say, well, it's pretty reasonable because he's got a bunch of grand trees over here and he couldn't put the patio on this side of the house. Or the way the lot line is, it really slopes in and you lose part of your yard on this side, so you have to put the patio in this one spot. And that's why I asked the question before, is have you looked at any other options? I don't see any other option. I don't see any other reasoning of why you're asking us to break the rules to get this variance. And I don't mean that in a bad way. I'm just saying that's why you're here, for the variance. And I'm asking, is there something else that I don't know? Is there a grand tree that's real close? The only things I've heard tonight is that you want to hear nature in the back and you want to experience some great things, which are all valid concerns and great things I'd like to do. But you can't do that when you want to break the rules. And the setback is there for a reason, so that we don't disturb the wetland, we don't do things. And if we let everybody want to come in that want to here's a bird just to build a patio, we wouldn't need the setback requirement. So I'm looking for an answer from you for some other reason of why you're losing part of your property to put the patio in this area and the patio of this size. Because you could do a smaller patio and you might only put out a small little corner. You could do a smaller deck, but you've got a very large deck and a very large patio. And I understand you want it, but for us to break the rules and grant this variance, we have to have some other reason. And right now, I'm not at that threshold, unless you can explain more.
One of the reasons why I chose the size that I did was if we were to go back to one of the pictures where you can see the backyard and the yard is covered in pine straw.
We'll go to any picture you want.
Yeah,
That one
and the 12-foot length does not come out to where the tree is. It's kind of hard to tell in the picture.
But that's
we're
the
not
setback, isn't it?
Excuse me?
The trees are in the setback, aren't they?
Well, technically, the pine straw is in a good portion of the setback. And so the deck would only go out to about maybe a foot closer to the house than from the trees. It would not touch the trees at all, and that's across the whole yard. And so when the house was originally built, that yard was all pine strawed in and indicated that it was our yard and usable yard. It was cleared and accessible. And so, you know, not really utilizing the pine straw portion, we were looking at putting the deck on top of it, and that was one of the reasons why I dimensioned the deck as I did.
Just so you know where I stand, I don't have as much problem with the deck as I do with the patio, because I think more than half the patio is into the setback area. So if for my one vote, I could slide to get you approval for the deck from my side, but the patio is what is my holdup. I think the patio is just the icing on the cake, pushing it too far for me. So that's just where I am, but there's 6 of us up here. Okay. Thank you, Mr. Chair.
Okay. Thank you so very much for your testimony today. Thank you,
You're welcome.
Mr. Reed.
What's next?
I'm going to go right through the process. I'm going to
Okay.
see if you brought anybody else in support. Would be the
I
next
did not.
step. Okay. Well, you never know. Somebody might.
I did not knowingly bring anyone to support. They did receive their letters, and no one expressed any objection to me. It's more of it's your yard kind of thing. So from that perspective, I feel pretty good. If the holdup for the majority of the board is the size of the patio, I can and will easily make amendments to that. That's pretty simple. But I'm anxious to move this process along, I guess.
For the benefit of the doubt, that I know you did come in here late. You did not hear the first part of the information that I presented. So any approvals or disapprovals tonight are valid. But if we disapprove your application tonight, you can't come before this board until 12 months from now, unless it goes before circuit court, okay? If you request a referral, then within 90 days, you can contact staff and get back on the agenda, okay, with any recommendations and improvements and changes to the plan, okay? So once again, if we go through with a vote and you are disapproved, you can't move forward with this design that you currently have,
Right.
okay? And then, like I said, if you request a deferral, you want to change it, at least you got to come back in 90 days or within that time period after talking with staff. I know that you missed that part of it because you came in late, okay?
Yes.
But I wanted to make that
I
aware.
appreciate you going
Okay.
back for me.
You can just, based off the information that you've heard and the questions that you've heard from these board members, kind of filling us out and seeing where we're going. We don't know until we take a vote.
I can't poll the board?
No, that doesn't work that way, unfortunately.
He's got a chance to rebuttal, so let's just.
Well, yeah. Well, that's,
Okay, well, I guess to ensure a smoother transition, I will defer and come back and change some of the patio dimensions just to make it easier for the board to support the request. And at the same time, my sense is that I should also move forward with the HOA and bring that to bear to the attention of the committee as well.
you sound like a very brilliant man.
Thank you.
Yes, sir. So if you would formally request that, that's what I'm hearing.
I will formally request a deferral for I guess it's 90 days, or within 90 days,
Up to 90 days.
and revise my application based on what I've heard tonight, and be back.
All right, so board members, we have received a request for referral. Do I have a motion to accept?
I move we accept.
Okay, all right. All those, first, any question?
You get a second?
He just seconded. Any question? All those in favor, please indicate by saying aye and raising your right hand.
Aye.
Aye. Is that everybody? It is unanimous.
Thank you.
Thank you, sir. So within 90 days, you will need to contact this board, not this board, but this staff, to get updated information and bring your plans so that you can see if there's any changes that they can make so that you can come before this board, okay?
Okay,
Clear as mud?
very good.
Thank you
A
so
little
very
bit
much.
better than the POV HOA discussion.
Very good. Thank you, Mr. Reed. All right. So our next case will be done again by Ms. White. It's case BZA 1124-00822.
Yes, sir, thank you. So the applicants and owners are Leonard Newton and Annie Newton. The property is located at 7224 Commodore Road in the St. Paul's area. It's TMS number 127-10-00-040, and it is in the agricultural residential AGR zoning district. It is a variance request to reduce the required 30-foot rear setback by 23 feet to 7 feet, and to reduce the required 15-foot interior side setback by 4 feet to 11 feet for an existing unpermitted detached accessory structure, which is a pole shed building. This is the subject property highlighted in a greenish color. All the properties around it are also zoned agricultural residential. This is the section of our ordinance that includes the density, intensity, and dimensional standards for the AGR zoning district, and we've got the interior side and rear setbacks highlighted here. This map shows and highlights the parcels that were included in the 300-foot radius notification. This is an aerial of the subject property. You can see the house, and then kind of in my right-hand corner, there is the shed that's existing, that they're requesting the variance for. And then this is a zoomed-out aerial of the general vicinity. Staff conducted a site visit on December 13th and posted the sign at that time. These are some photos of the subject property. So the first one on the left is looking down the driveway at the house. On the right, that's the side of the shed. And then you can see photos of the side and the front of the shed here. Again, you can see the photo of the shed on the left, and then some additional area of the house in the yard, and the photo on the right. Okay, this is a little hard to see, but on this is the site plan, and you can see the pole shed location in the top right corner. This is a plat that includes the property, which is starred. And for the variance criteria, staff reviewed it and found that the request meets criteria 1, 2, 3, 5, and 6, and may meet criteria 4 and 7. And if the board approves this request, staff suggests a condition that states that the applicant shall obtain all required zoning and building permits for the unpermitted accessory structure. Thank you.
Any questions for Ms. White? Yes, sir, Mr. Neal.
Thank you, Mr. Chair. I'm looking at the aerial photos. It's from 2009, and then the layout right behind it. So it's my page 21. That area, yeah, that's one aerial photo. But then if you keep going in our thing, keep going to the next to last. Yeah, keep all the way. It's the next to last slide, I think.
This one.
I'm just looking at it because they had a thing on here that said Charleston County GIS aerial imaging 2009. I'm trying to understand, is the pole barn not in that picture? Because it said somewhere in the application that it was there at least 20 years ago, and if it wasn't, who's right? I don't have a problem with the applicant that bought the property in 2015. It was there. I'm just trying to understand how long has it been there.
Sure.
It clearly was there when they bought the property. But I'm trying to find out, and this aerial, I'm the only one looking at it, is page 20 of our slide presentation is the one I'm looking at. It's not that one.
It's one or two right before the site plan.
It's two before the site plan.
So it's in the presentation. So is it this one that's up? Is it this one right here that's up behind you?
No, it's a different one.
It's the black and white one?
It's a black and white.
Oh, okay, so that's the plat for the subdivision of the area.
No.
So
No.
not this
Photo.
one?
No, it's not that.
This one?
It's just not, it's not
Keep
even
coming
slide.
back. You don't,
Here?
I'm looking right at it. It's in my packet.
Do you mind if I come look so I can see?
It's not in hers.
Yeah, it's right here. It's
Not in yours either.
aerial image 2009. That's different from the one you're showing, and it doesn't show it.
It's right there.
Huh?
I think that's
That's it right there?
Yes, sir. Yep. Yeah.
It's in the bottom?
I don't have the presentation.
Yeah.
Okay. So she's saying it's in the lower right-hand corner of the lot. So it was there in 2009. So that addresses my question.
Yeah, if you
That's what I
look,
wanted to know.
this is it right here. I know this is a newer aerial, but just to give you context, if you look at this screen, I've got the pointer.
Okay.
That's it right there.
Okay. Thank you very much.
Yes, sir.
Any more questions for Ms. White? Thank you so very much. Is the applicant present? All right, Mr. Newton. All right, okay. Mr. Newton, if you would, please state your name and address for the record, and please tell us why we should approve your application, sir.
All right, my name is Leonard L. Newton. I live at 7224 Commodore Road in Hollywood, and that's the property in question, and it's now my primary residence. My wife Ann and I bought the property from the bank as a foreclosure in 2015, and we've lived there since 2015. And in October of this past year, in 24, we went to the county to get a building permit to put a garage on the concrete pad that was there when we acquired the property. We bought the house, the driveway, a concrete pad, and this pole shed was on the property when we purchased the property. Upon applying for the permit for the new garage, county staff informed us about this pole shed being within the setback, and this was the course of action for us to rectify the situation. So that's why we're here tonight.
Very good. Clean and to the point. We have
And the 2009 aerial photograph that I think Mr. Neal was mentioning just now was what we presented. We went back as far as we could on our phones with the county's GIS system to show that the shed, as far as we know, was built at least in 2009. By county tax records, they've been showing it as taxable as a accessory structure since 2005. So with the time that it was built, if it was built in 2005 to now, it's been there at least 19 years.
Yes, sir.
So it's kind of been accepted within the community for a while.
Tell us about this proposed garage that you're going to put up there.
Okay, well, like I said, it's a concrete pad was there at the end of the driveway when we acquired the property. And so we were going to put up one of these Carolina carport enclosed garages at the end of the driveway on the concrete pad. The concrete pad is not in the setback. Just the pole structure at the back of the property is within the setback.
Okay.
But we couldn't get a permit on the new garage till we solved the addition with the pole shed.
Right.
Yes, sir.
So you got caught with your hand in the cookie bag, even though you didn't put your hand in the cookie box.
But this was, according to Mr. Neal, number 6. Is it any of your action why you're here? And it's not ours. You can take it up with the previous owner if you can find it.
Okay. Let's see if any one of these board members have a question for you, Mr. Newton. Anyone?
Nope.
Thank you so very much for your colorful testimony today, sir. Thank you.
You're welcome.
All right. Very good. Do we have anyone else to speak in support of this application? Do we have anyone else to speak in support? You may be seated, Mr. Newton, if you like. Do we have anyone to speak in opposition? Do we have anyone to speak in opposition? Very good. This case is closed to the public. Board members, do you have any questions of staff? Do we have any general discussion? If not, then,
Motion.
well, I also have Mr. Siddell here. I'm going to give him a shot there.
Ready.
Thank you, Mr. Chairman.
Yes.
In the BZA,
You got it here.
in the BZA case 11-24-008, 00822, I move that we approve this variance. I find that it meets all 7 of the criteria required for variances. There were extraordinary and exceptional conditions pertaining to this property. The pole barn was already present when the current owner bought the property and has been there at least probably around 15 years at minimum. The conditions do not apply to other properties in the vicinity. There was not mentioned, but it was submitted that there were other structures of similar types in that community. So it's not really going to be a detriment to other properties in the vicinity. Unnecessary prohibits the usage of the property. In this case, this structure has been there. It was there when the current applicant bought the property, so it's been accepted, and it would be restrictions of his use if it was caused to be removed. The variance will not substantially detriment to the adjacent property of the public good. I think it's been there for that long. There's been no complaints brought to the county about that property by other adjacent property owners. It will not use to establish a use that's not permitted in the zoning district. It meets that requirement. And as we've heard, it is not a variance request as a result of the applicant's own actions. And it meets the condition that it does not conflict with the comprehensive plan. And then part of my motion will include the conditions set by staff.
Okay, we have a motion. Do we have a second? All right. We just have
I would add one comment, is the applicant should be commended for following the correct process when he discovered that a problem existed, so thank you.
Good. Thank you. So we have a motion that's been properly moved and second. Very good. All those in favor, please indicate by saying aye and raise your right hand. Aye. Any opposed? It's unanimous. It carries. So there you go. Your application has been approved. Within 10 days, you'll be getting information from staff letting you know the next steps in the process. Thank you so very much for coming, Mr. Newton, and you have a very good evening, you and your wife. Thank you. Thank you. Okay, we're going to kind of go through this one, and then after this one, we'll take a break, okay? So our next case is case BZA 1124-00823, and that will be done by Ms. Brooks.
All right, thank you. Let's see, here we are. The applicant and property owner, J. Marshall Milligan, is requesting a variance to remove 3 grand trees for a proposed single-family residence at 311 Papa Charlie Way, TMS 33412000016 on James Island. More specifically, the applicant is requesting to remove a 24-inch DBH grand red maple tree, a 24-28, that's a double grand live oak tree, and a 32-inch DBH grand Darlington oak tree. The subject property and adjacent properties to the east, south, and west are located in the Special Management S3 zoning district. Adjacent properties to the north are located in the low-density R4 residential zoning district. The 0.71 acre property is currently vacant. The applicant is proposing to construct a single-family residence. The property contains 8 grand trees. The applicant property owner plans to preserve 76 inches DBH grand triple oak tree and a 28-inch DBH grand oak tree located in the front of the property, and a 30-inch grand oak located to the rear of the property. There were 2 trees, a 40-inch and a 48-inch DBH grand oak, that were permitted to be removed administratively because upon inspection they were deemed to be dead, diseased, or dying. The applicant's letter of intent explains this lot is heavily wooded, and taking these 3 trees down does not present a significant impact to the integrity of the lot due to the many other trees present. However, they pose a significant obstacle to building a home on the lot. So looking at the rest of the case information, here is the zoning ordinance with the tree protection and preservation article. Here's the 300-foot radius for the notification for the case, outlined in the blue color. And aerial photograph zoomed in of the property, vacant wooded lot, and zoom out for more of a location view. Let's see, staff conducted the site visit of the property on December 12th, 2024. Here's some pictures from the site visit. And some pictures of the trees requested: 24-inch red maple, the double live oak, and the 32-inch Darlington oak. Some pictures of the subject property. And here is the site plan and tree survey for the property. You can see the different trees that are highlighted. And they did include some elevation plans for the proposed home. So for the variance criteria, staff found that they may meet criteria 1, 2, 3, 4, 6, and 7, and they meet criteria 5. In the event the board decides to approve the application, the board staff recommends the following conditions, and I'll read through these. The applicant, number 1, the applicant shall mitigate the removal of the 108 inches total DBH by either A, submitting a mitigation plan for review and approval indicating the installation of canopy trees no smaller than 2 1/2 inches in caliper equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 9.2.6 of the ZLDR, or C, a combination of both A and B. The allotted mitigation shall be in place prior to the tree's removal. Condition 2, tree barricades constructed of chain link fencing shall be installed around all protected trees within 40 feet of disturbance prior to any construction pursuant to section 9.2.4 of the Charleston County Zoning and Land Development Regulations. And condition 3, the applicant shall retain a certified arborist to monitor and treat all grand trees within 40 feet of disturbance through the duration of construction. The applicant shall provide a copy of the tree preservation plan to the zoning staff for review and approval prior to zoning permit approval for construction. Does the board have any questions?
Mr. Neal.
For staff?
Chair, 2 of them. One, what is the zoning on this and restrictions on how big of a house or minimum house can be, or how big for this lot?
Right, so if, this was in the, here's the zoning map. Let's pull that back up.
Pretty good sized house.
Yeah, so S3, it would be based on like building size, lot coverage, square footage, and that's in the table.
Is there a minimum? Not a minimum.
So yeah, I think it's called out like 40% for a lot coverage, and that would include like impervious, excuse me, for house, anything that's, yeah, and
Okay.
the driveway, but with an option to potentially go beyond that with approved BMPs through the county stormwater division.
Right. Okay, and then my second one is on the trees, kind of a 2-part question. One is, what are the grades of the red maple, the Darlington oak, and live oak? And I do not know what a Darlington oak is.
I don't either.
Well, I'm
So
glad that
I can't wait to hear this
my
description.
associate Kyle is here to help.
But yeah, what were the grades?
The grades, the maple and the oak, the maple and the Darlington oak are both A-grade trees. The live oak I would call a C, only because the canopies of the other trees around them are shading it out, so it does have some loss of a canopy. But the tree has no disease or pest otherwise. A Darlington oak is essentially a laurel oak or a water oak.
Okay.
The leaf shape is just a bit dissimilar. trying to describe a leaf shape. So a laurel oak has a very long, ovate or oval-shaped leaf. A Darlington oak is basically the same shape, but it has these little ridges on the sides called tines. That's the only difference.
Never heard of the Darlington oak term. And the trees that was done at administrative level, were they Fs or Ds? I mean, they were dead?
They were very rotten and decayed.
Were they? Okay. All right, thank you, Mr. Chair.
Yes, sir. Actually, I got a follow-up question. You said you compare this to a water oak. Is that correct?
That's correct.
Does it have a very shallow root system like a water oak?
Most hardwoods in the southeast have about the same depth of root systems. So they only go down an average of about 5 or 6 inches.
Why is it that water oaks topple in windstorms and live oaks don't?
They're more prone to having decay. They don't compartmentalize decay and infections.
I see. And do Darlington oaks have that same susceptibility?
That is, yes.
Yes, okay.
This specimen in particular actually is quite healthy.
Good question. I learned something tonight. Anybody else? Ms. Smith? No. Thank you so very much, Ms. Brooks. Is the applicant present? Yes, sir. All right. If you would, please, sir, state your name and address for the record, and please tell us why we should approve your application, sir.
Good evening. My name's Jay Marshall Milligan, and my address is 125A Wahoo Creek Drive on James Island, 29412. And thank you, and Happy New Year. The age-old question, if a tree falls in the woods, right, yeah, in Darlington. You know, as we went through the 7 criteria, I really feel like that because of the substance and nature of this property, and if you looked at the aerials, I mean, you can't even see the ground because there's so much tree cover on this property. And there's 3 big trees that are going to be remaining, probably in addition to a number of trees that are under the 24-inch threshold that are still going to be left on the property. There's a significant impact of a Charleston County drainage easement on the western edge of the property that brings the setbacks in, and we also had to, if you can notice from the GIS images, it looks like it's a landlocked lot, but there's actually on the plat that I recorded, we created an easement to run back there, and the easement has to go into this lot somewhat significantly to allow for emergency vehicle turnaround at the end. So if they have to go all the way back to the back lot, they have a way for the fire engine to get out of the property. So that brings the setback kind of up and in. So where you see this 2,500 square foot house footprint is really about the only place it can go on the lot. And when you looked at the screen with the highlights, the 3 green ones were the ones we're requesting to remove, and the 2 yellow ones are the ones that have already been approved. But you can see that the 30-inch in the back and the 76, I think, and the 24 or whatever it is on the front right of the property are all going to stay. And so I don't think it really, there's a problem with any of the 7 major criteria, given that it's really a moderate house plan. We're not trying to put up a $3 million mansion on a 0.7 acre lot on James Island. It's about the only size house we can fit on that lot. And you've really got the easements kind of create the area where the house has to sit. So I think when you take all of it into consideration, the fact that I'm not asking to raise a lot and remove every tree on the lot, that I really am sensitive. I grew up on James Island. I'm sensitive. This is a rural, kind of unincorporated area of James Island, and I grew up on the other side of the island at the end of Harborview Road. My yard had a live oak, and still there, that's as big almost as the well area that I climbed in as a kid. So I'm sensitive to that, but also the purpose of having a vacant lot like this is to build a house on it, in my opinion, so that we can have people come and enjoy this beautiful part of the city. So that's why I'm asking for the trees to come down.
Okay. Thank you for your testimony. Just before any other board members ask you a question, are you going to reside in this house, Mr.
No.
Smith? You're not?
No.
Great question.
Okay. So, Ms. Smith, you had a question?
That was my question.
Oh, I'm sorry. I don't, as chairperson, I don't like to steal
thunder.
questions. Mr. Neal?
Yeah, I mean, on the same train, so are you part of the development group? Explain what's going on. It looks like this was
I'm the
a
manager of the LLC that owns it, Tiger Devil.
Yeah, so this was a 3-lot development. Y'all bought the whole thing, split it up, and this is the last piece of the
Yeah,
puzzle?
it was always 3 lots. The plat of record when I bought it was 2, but then at some point the middle lot was created by deed and county was taxing it as 3. So I recorded an updated plat. We left the house on the front lot and rehabbed it, and that's listed.
Is this going to be a spec house, or is this a house for contract, like build to suit type thing, or? The reason I ask is because that goes into the question of are we building a house and creating our own issue here, or is this your house and your dream house and you're trying to build it and you were trying to get through a couple of things?
No, it's a spec house that a builder is going to build that's going to get listed at the end.
Okay, thank you. Thank you, Mr. Chair.
Mr. Brown?
I'm curious if you've considered any alternate designs or shifts or locations.
Man, we move that thing around as much as you can move it, based on the setbacks because of the drainage easement on the side and the easement coming in on the bottom, and there's a drainage easement on the back of the property. So at the very top of that, what you're looking at there's a drainage easement there and on the left side as you're looking at that. So where that house sits based on the setbacks is about the only place you could put it.
Have you potentially looked at shifting where the driveway is to the front of the house instead of on the side like that? That would give you potentially more room on the left-hand side to move it.
Yeah, so where you see that easement come in on the bottom there, that's the easement that runs along the eastern boundary of the middle and front lots, if that makes sense. So the only place it can enter that lot is right there. And then you've got to have...
I meant your garage entrance that's on the side of the house versus another location.
I don't know that where the driveway is would impact any of the 3 trees that need to come down based on... Yeah, I'm not sure I'm seeing driveway on what you're looking at.
He's thinking about the emergency turnaround area.
Well, I'm looking at how you entered the garage, and if then you've got a driveway that's kind of right over against the easement, and that's kind of causing where the house is being located. Where, if I'm reading it correctly, if that driveway weren't there, the house would be able to shift.
I'm not exactly sure where you're seeing a driveway on the drawings. Can you get the one you're looking at pulled up so I can see?
I'm looking at this plan right here. Isn't the driveway and the entrance to the garage on the left-hand side of where the house sits on what I'm looking at here?
Just
I don't
left
know
of the
that
four.
They even drew the driveway on this.
They didn't draw it on there. He's just assuming where the driveway is going to be for.
I see a driveway with a turnaround and where the garage lines up on the house plans.
It's like,
Right there. Yeah.
Right to
Yeah.
the, well, yeah. There you go.
I mean, I think you may be able to shift it a little bit if you brought the driveway directly in and ended it there, but you're still going to have a problem with and I don't have a good color copier in my office, so as you're looking at it, the tree that's on the left and the tree that's in the middle that need to get variances for, the 30-inch on the right, that's the Darlington oak, I believe, if that's right. That could potentially bring it out of the canopy for that one, and you could potentially leave that one tree. But I think the 2 middle ones, I don't think there's any way to shift that house in a position that won't impact those.
I was just looking at, is there a way to save any of the 3 trees that you want to take out?
Yeah.
And save you money in the long.
I was kind of hoping an eye for an eye. I'm saving 3 and taking 3. You know, I mean, that's really kind of where my thought process is on it. I don't want to take down all the trees. I love trees, but you know. I think the way this lot sits, some trees are going to have to come down if it's ever to be developed.
Mr. Neal?
Yeah, just a follow-up. I'm curious on the mitigation that would be required. Are you planning on planting trees or tree banking?
I'm not sure. I didn't look and see what I don't know what monetary amounts those would be, but we would be open to either or. I don't have
That's
a problem
fine.
with any of those.
I was just curious
Yeah.
if you had studied. Okay, thank
Yeah.
you. Thank you, Mr. Chair.
Anyone else have a question? Thank you so very much for your
you.
testimony today. Do we have anyone else to speak in favor of this application? Do we have anyone else to speak in favor of this application? Do we have anyone to speak in opposition for this application? Anyone to speak in opposition? Very good. This case is closed to the public. Board members, do you have any questions of staff? Any discussion? Well, I have a discussion question. On my tenure here, I think only thing that's required of us is a 40 by, correct me, Miss White and Miss Brooks, if I'm not mistaken, we're required to ensure that they have a 40 by 40 buildable footprint. Am I correct?
That's a minimum
That's the minimum.
building size, 1,600 square feet with a minimum 20-foot width.
And I'm looking here at a 2,500 square foot footprint. Am I correct? And I'm also noticing that we have, if we go back to the slides, to where we have the administrative trees being removed and the 3 in green that have been requested.
Right. The green trees are apparently the ones on the request. The 2 that are yellow are the ones approved by staff because they were dead, diseased, or dying. Yeah.
Correct. Correct.
And then there's some other trees you can see that no highlights, but those will remain.
Correct. I believe that they can come with a different plan. I could see if this was a house in which he was going to live in and needed it because that was their dream home. I see that these trees that are on the very edge, and I imagine it's the canopy that's going to be encroaching upon this footprint. I think they can build something a little smaller, although it might not be advantageous to them, but build something a little smaller that could fit within this parcel to maybe not have to remove all 3 of these trees, is my thought for general discussion, board members. I think the county and the staff has worked very diligently with them to administratively remove some of the oaks, but I think they could try a little harder. Mr. Neal?
Yeah, Mr. Chair, if I can follow up on that comment. I mean, my first question that I let out on staff was what are the minimum footprints required for this zoning? I mean, can they put a smaller house? And if the answer is we can put a smaller house on here, then it would fall under the category of number 6 that we always struggle with. The criteria of number 6, the need for the variance is not the result of the applicant's own actions. Although I applaud the applicant for trying to save every tree, and I think it's great, but I think what I'm looking at, and it sounds like the tone of your question is, can we do a different plan? Can we do a different house? Well, if you do this big of a house, you need the trees to be gone, but can he still use the property if he has a smaller house? And I think the question is yes. Would it be advantageous to the property and they're selling it or whatever they're doing with it? So I'm struggling with getting across the finish line on number 6 as well, because I think they could do a smaller house. I'm not an architect and can't design anything for them. And if that resulted in only losing 2 trees instead of 3 trees, then we'd be looking at a different variance here. So I am on the same page as you, Mr. Chair, on this issue here. I'm struggling with the size of this house for these trees. Thank you.
Any other discussion? Yes, sir. Mr. Brown?
I think that's where I was getting at too, is just to kind of add on that I think we could save at least one of the trees, possibly two, looking at some alternatives and shifting some things here and there. I am an architect, so I can see some possibilities of what might.
You're doing it in about a half hour.
What might could happen. So I just want to state that. I think there is a way to save possibly two trees with some minor adjustments.
You know, this is close to the public, but, Mr. Hugie, I know I may have the pleasure of asking this gentleman to ask, I think we can ask a question of him if, I know I can ask.
Can I ask a question of you?
Not right. Well, no.
Not yet?
Not yet. I'm saying that if there's a board member that had a question of this applicant, they could ask a question that would reopen this opportunity. Maybe he would ask for a deferral or something like that. But, Mr. Neal?
Mr. Chair, is to the applicant, is.
You have a question for the applicant, Mr. Neal?
I do have a question for the
So
applicant.
at this time, I'll ask the applicant to come back to the podium and see if you would address this question that Mr. Neal has.
Thank you.
So, and I don't know if you'll be able to answer this because this is stretching into the future, but it looks like the two trees that are very close to the front porch, and I guess that's the garage end of the house, if the house was able to shift a little bit, could you save those trees and then come back for a variance that encroached the canopy but didn't affect the tree, having to take the tree down? Because then at that point you would change your variance to only losing the one tree and then going into the tree canopy.
Right, which, as you're looking.
Please talk into the mic, if you would, please.
Oh, I'm sorry.
That's
I'm
okay.
leaning forward to get a closer look because my eyes aren't as good as they used to be.
Welcome to my world.
You're talking about the tree on the right and middle, that one and those two, to try to save one of those? Both potentially? Under that question, you're assuming that the 30-inch on the right is okay based on moving it a little bit?
I don't know, but like I said, I think so if you're open to that, then the solution would probably be ask for a deferral, make some adjustments, and bring that back up. If not, we're happy to vote on this proposal tonight because we've actually even closed it and opened it back up because of my one question.
Right.
But that's just where we are.
No, I get it.
In trying to move this down the road.
Are we open now?
Now you can ask me a question.
Are we open?
You
Yeah.
can ask a question.
I would request a deferment.
Okay.
At the next meeting.
At this time, board members, the applicant is asking for a deferral. That is the motion. Well, there's not. Will somebody make a motion to accept that motion?
Go ahead.
Would somebody do that, please?
I'll make a motion.
To accept the, okay. Do we have a second? Okay, so we have a motion and a second to defer this case. Any discussion?
Excuse me, who actually seconded the deferral?
Mr. Truslow.
Thank you.
Truslow seconded it.
Thank you.
So at this time, we'll come to a vote. All those in favor, please indicate by saying aye and raising your right hand. Aye. Aye. It carries. It's unanimous.
Thank you very much.
So yes, sir. You have been given the approval to get a deferral. Within 90 days, please see this wonderful staff to get everything straight and make some changes to your plans so that you can come before this board again.
Thank you.
Okay, thank you.
Have a nice evening.
So at this time, we're going to have a 10-minute recess. Thank you.
Just move the whole thing back.
This is so.
Enter here.
Two things. This is the most different cases we've ever had since I've been on here. Different issues on cases. I mean, you got one for short-term rentals, you got one with a PD, you got this, and this is the most deferrals we've ever had.
Yeah, just kicking down the road. They're gonna come back.
I would have, I would have approved it.
I would have approved that already.
Oh, no, I'm saying, you get one coat again next, Sally.
I wonder if she's watching this.
Oh, she is?
Is it Jenny? Yeah, my wife and our brother now.
I'll
They
start
come up
over.
back there.
Okay, yep.
Let me
Okay.
start over. So right now,
Okay.
we're going to reconvene, and we'll do case BZA 11-24-00824, and Ms. Brooks will be administering this first case.
Okay.
Thank you.
Yep. The applicant and property owner, Sagar Barrett, represented by Brandon Emsley of Blue Haven Pools, is requesting a variance to reduce the required 25-foot rear setback by 4.4 feet to 20.9 feet at the closest point for the proposed swimming pool at 1543 Gator Track, TMS 28613000166 in the St. Andrews area of Charleston County. The subject property and adjacent properties are located in the Planned Development PD 73E Hunt Club zoning district. The 0.18 acre subject property contains a single-family residence that was constructed in 2005 per Charleston County records. Here is the zoning map showing the PD here in the blue color and the other surrounding zoning districts. Yellow is single-family residential, purple is industrial, red is commercial. And a copy of the zoning ordinance and PD document with the regulations. Here is the 300-foot radius map for advertising the case. The property is outlined in blue. And an aerial photograph zoomed in of the subject property and a zoom out of the surrounding properties. Staff conducted a site visit of the subject property on December 12th, 2024. Here's some pictures of the subject property. Here is the site plan outlining the location of the pool and the setbacks and everything for you to see. Existing residents. And a zoomed in picture of that. And here's the plat with the property starred in blue down at the end of Gator Track. Staff review approval criteria found that the request may meet criteria 1, 2, 3, 4, 6, and 7, and meets criteria 5. In the case that the board decides to approve the application, please consider the following condition recommended by staff, and it is the encroachment area shall be limited to the footprint shown on the submitted site plan. Does
anybody have a question of staff?
Mr. Neal?
Application, thank you, Mr. Chair. The application that the applicant filled out on number 5 said, when asked about not granting variance and conformance, it says the variance, their own knowledge says the variance request does not meet this criteria to my knowledge. Is that a mistake in the application or just a informational error that we can disregard?
Is that part on their letter of intent? Is that what you?
Yeah, I mean, their letter,
Oh,
I mean,
okay.
it says the variance request does not meet this criteria to my knowledge. And I want to just make sure that we can disregard that.
Yeah, as a response from the applicant, that might be a good question for them. However, staff found that it did meet this. This is based on uses allowed in the zoning district.
Right, I figured that was. And then, Mr. Chair, just a procedural question. I don't know, I mean, because this application brings it up. I love seeing some type of approval from from a POA or an HOA on the front end.
There's
And
one in there.
Yeah, I know. I'm saying, so I would love to see this if there's some type of, I don't know if it's in the statute or ordinance or whatever, how we can require this or give us some type of, they've applied, we don't see any problem, but we still, we support this action. And having that, if that's something that staff can can recommend or something, I don't know, but it just makes things easier and quicker, because it looks like this is a very easy submittal.
So staff is hearing you. And so whenever these applications come up,
Yes.
that might be something staff can mention. You know, they're hearing this now. So
It'll save us
if they
some-
want to be successful and improve their chances of being successful here,
It just changes the tone of the application, that they've gone through the hoops that we want, and then it's just an easier application from our standpoint.
you make a very valid point, sir.
Thank you, Mr. Chair.
Any other questions for staff? Thank you, Ms. Brooks. Is the applicant present? Very good. Yes, sir. Please come forward. Please state your name and address, and please tell us why we should approve your application, sir.
Hi, my name is Sagar Bhatt. Good evening. I'm living at 1547 Gator Track, Charleston, South Carolina, 29414. I'm trying to build a swimming pool in my backyard. I have a newborn, and my family was like, my wife was like, we should do the pool or something like that. So I had approached the company. And when I bought the basically house, I had no idea that you have to easement and you have to go through all that stuff to apply for the pool. So I gone and got the company that they got come on. They all kind of designing and all this stuff. See, I have a trees in my backyard too, which I didn't want to cut it down. And I have probably like 5 or 6 different trees in the backyard, which I didn't want to cut it down. And that's the only layout I can get. And by cutting to the easement, there is no utility or run line. There is nothing in my backyard. It's like, harass anybody to go approaching the easement. It's already two-way that people can approach the easement if they wanted to. So that's the only thing. And I did have a HOA approval also. I did apply for the HOA first before I come over here, just to make it easier for you guys.
Okay. Anything else you want to tell us?
I just want you to approve it so I can enjoy it. That's all.
You want to swim?
So you're asking for 4 feet, right?
Yes, sir. Yes, sir. It's
Okay.
basically. I'm sorry if I may allow.
No, go ahead. You talking.
I did come up with the different plans. We did try to. I can show him. I have so many different plans to cover, but that's the only way. I could have gone the other side, but I have to cut down all the trees and everything. And this is the only way that I could have just cut into the. I can understand that if it's like a utility, any kind of a power line or anything run through it, but there is nothing. It's just like a waste pond back there, like all the the ponds. And there is nothing else in the back, and that's the only layout I think by cutting into the 4 feet would enjoy, because if I wouldn't cut, I wouldn't have no pool. So I want to enjoy at least a little.
We want
bigger
you
pool.
to enjoy it, but let me ask you this.
Yes, sir.
You said you had a couple other drawings, right?
Yes,
And
but-
layouts.
Okay,
So,
sorry.
and then you also said that on the other side you would have to remove some trees.
Yeah, see,
So there are pine trees, right?
I guess I'm not. No, I have no idea. The only
So
thing
if I look at your drawing, I see pine trees that are on the other side.
but that would give me on the street view. So it would be like on my neighbor looking at me while I'm in the pool, it would just look like, I don't know, it was just and this is the only layout. By crossing the 4-inch into the easement wouldn't disrupt no easement, and it would be accessible for everything. And my neighbor
that's
had,
oak tree. I'm
and my neighbor had say that they don't have any objection, or nobody has a. There are other people across from me has a pool and all the stuff, but I don't know the variance and all the stuff. But it's like a bunch of people has it, and that's my only goal. I had no idea anything else.
Do you know how big that other tree is on the other side if you had to move it over?
It's bigger than my arms, I'm sure. It's big. It's big. It's big. It's big, and there is no way I couldn't go on either of the side. There's only because I have to move even the stairs to get on that much, because first I wanted to build it a little further, but I didn't want to go in the easement so much. That's all I'm asking for, 4 feet on cutting the easement, which is not going to disrupt anything, because basically it's nothing behind it.
Yes, sir. So your pool is 12 by 30, right?
Yes, I guess it's 13 or 12 by 30. It's just whatever. Yes, sir.
Do you think you could have had a smaller pool?
But
30 feet's a long pool,
but
right?
that's not the problem. It's a wider the problem. The 12, the 30. The length is not the problem.
Mm-hmm.
It's the wide of the problem.
The width?
Yes, the width, sir. That's where I'm cutting into the easement. I would have cut it down a little bit if I had, going to the easement, I would have cut it down. The only reason I choose to because I wanted to go like 15 feet. But then I knew that I would cut into the easement so much, and I know you're definitely not going to approve me then. So I was like, I can take a chance with 4 feet cutting into because it's not going to disrupt, like I said, anything to the easement.
Okay, let's see if any other board member have a question for
Yes,
you.
sir.
Anyone
Yes.
have a question? Okay, wow, that went by over quickly. Well, thank you so very much for your testimony and answering my questions. Wait a minute, did someone else have a question? No? Okay. Thank you. Do we have anyone else to speak in favor of this application?
Well, can we go back for just a second?
Okay, can I get you to come back?
I'm still trying to follow the law on this.
Yes, sir.
And do you have your PD document so I can see what's I haven't seen the PD document.
It's called HOA approval. You're talking about HOA approval,
Well, I
right?
saw the ARB, but I didn't see HOA. And I
it is the-
couldn't follow the.
ARB is part of HOA.
That's part
Pardon
of
me?
it. That's all.
That's their design review of the nature of that.
Yeah.
That's the approval.
Is that the only, I don't know what I don't know what their homeowner
Yes, this is the
documents
only
say.
thing. This is
What
the
we
only
need.
thing they gave us.
I couldn't hear what Mr. Neal said.
We need something from the HOA, and that's their main document.
Well, that's what, I'm with Mr. Neal on that. So my second question is whether, and this is unprecedented
Yes, sir.
in my time here, but would you be in favor of a deferral?
No, just, let's clarify. HOAs have design review committees, and they're the ones that issue the approval
And they've
for
done
the
that.
HOA.
And they've done it.
And they've done it.
Well, that may be, but I haven't seen the document that says that.
I did submit it.
It's in here.
Is it in the pack? Is
Yeah.
that's what's here?
Yeah. The HOA has approved it.
Okay.
17. Page 17, Mr. Drusler, and 18.
I have this.
Here you go, it's right here.
I thought it was necessary to get the HOA approval before it comes here.
Okay.
We closed it, or we're just waiting?
No, it's still open.
Yeah.
It's still open.
It's closed?
No, it's open. Did you have a question?
No, I'm waiting to move forward.
He's just trying to find it on his iPad. Oh, he gave him mine. He gave him yours.
It's page 17 or 18, isn't it?
I don't think his had it on there.
It's not on here.
Yeah, I'm looking at it, page 17.
Yeah, but Mr. Truslow's iPad didn't have it on there.
Well, there's,
Look at it now.
Oh, you got it?
ARB approval.
Okay, he got it. We found it. Thank you for your patience.
You know, it's good.
All right. That's all I have.
Okay. Thank you so very much for your testimony, sir.
Thank you, sir.
Okay. Do we have anyone else to speak in favor of this application? Do we have anyone else to speak in favor? Do we have anyone to speak in opposition? Anyone to speak in opposition? Very good. This case is closed to the public. Board members, do we have any questions of staff? Do we have any questions of staff? Do we have
I do have one quick
Mr.
question.
Brown?
I just want to verify that there's a 20-foot drainage easement, but not shown on the plan as an additional 5 feet for the setback based on the zoning, right?
Right, so that 20-foot easement is within that 25-foot setback, but it's not like very clearly
Just
shown.
It doesn't show the 25-foot line anywhere on there to give a sense of where that is. Okay, just verifying, thanks.
Good question, Mr. Brown. Any other questions of staff? Very good. Can I get at this time, can I get a motion to either approve or deny in this case, 824? Yes, sir. Mr. Stadell.
Mr. Chairman, I move that we approve this request for a variance. I find that it meets all 7 of the criteria. There are extraordinary exceptional conditions. The easements are on this property are restrictive. And so there are extraordinary conditions don't apply to other property in the vicinity. All the lots are different, have different relationships to easements, so this is unique to this property. Third condition, unnecessary prohibits the use of the property. Yes, there's no room for a pool, and the applicant has testified that he's tried several different configurations for the pool, but this was the best one, provided a reasonable size for the pool. The variance will not substantially be a detriment to adjacent property or the public good. We heard from the applicant that there are other pools in the community, and that having a pool is not a detriment to neighbors. Will not establish a use not permitted in the zoning districts. It meets this criteria, would not establish a use that's not permitted. The variance is not the result of the applicant's actions. The house was already built when he bought the property. He didn't set the house in such a way that would create obstacles to the pool. And it does not substantially conflict with the comprehensive plan. And the motion includes the conditions set by staff.
Second.
Okay, and the conditions?
Yes, the one set by staff.
Oh, okay, okay, you did say that. Thank you. So we have a motion that's been properly moved and seconded. Any question or discussion? Okay, I'll call for the question. All those in favor, please indicate by saying aye and raising your right hand. Aye. Aye. Any opposed? There is one opposed. Very good. It does carry. So, where did he go? Okay, there you go. So, congratulations. Your application has been approved. Within 10 days, you'll be getting information from the staff letting you know exactly what to do in the next steps. Thank you so very much, and congratulations, and have a good night, sir. Okay, moving right along. Our next case is BZA 1124-00825, and that will be done by Ms. Brooks again.
Okay, yes, so we have two cases, so 00826 as well. I'm going to present them together because they're for the same project.
Correct.
And then at the end, if you would just vote on them separately.
Correct.
Yeah, okay.
Correct.
I'm
Thank
just
you.
going to go
Thank you
through
for
it
help.
all together. Good, all right. Okay. The applicant, Jessica Luzier of Stone Castings of Charleston, and the property owner, Russell Luzier of 2177 Ashley River Road Holdings, LLC, are requesting a variance to reduce the required buffers for a proposed building and vehicular maneuverability, and to eliminate the required parking lot, tree, landscape island for vehicular maneuverability at 2177 Ashley River Road, TMS 354-1200006 in the St. Andrews area of Charleston County. The 1.04 acre subject property is located in the Ashley River Road Corridor Overlay Neighborhood Commercial NC zoning district. Surrounding properties are located in the city of Charleston's jurisdiction, and you can see this on the zoning map, the kind of the gray hatch. That's city of Charleston. The subject property is long and narrow. The average length of the property is 758.25 feet, and it is 60 feet wide along Ashley River Road. The rear of the property borders the Mark Clark Expressway, I-526. The existing one-story building was constructed in 1985 per Charleston County record. It is 70.4 feet by 32.7 feet, approximately 2,280 square feet. And it previously contained dry cleaner use, was currently vacant. Okay. The proposed project is currently in the site plan review process, ZSPR 0924-01062. The representative for the project is Herbert Gilliam. The applicant's letter of intent explains, quote, the site was a dry cleaning business that has been abandoned for a number of years. The existing building is being renovated to be a showroom business office. A new 4,200 square foot building is being added behind the existing building where the precast pieces will be cast. The site is approximately 1.04 acres with a width of less than 60 feet. It will be a challenge for any occupancy to utilize the site. We are seeking a reduction in the side setbacks to allow for renovation of the existing building and construction of the new building. We are also seeking a variance to eliminate tree islands at the end of the parking rows to improve maneuverability requested by the fire chief, end quote. So the applicant is requesting a total of 2 variances. Case BZA 1124-00825, which is a variance request to reduce the required buffers. And the other case would be BZA 1124-00826, variance request to eliminate the required parking lot, tree, landscape islands. As far as some history on the property, a variance request to reduce the required 12.5 feet by 12.5 feet to 0 at the closest point to accommodate vehicular maneuverability around the existing building. That was approved with conditions on February 6th of 2023, along with a variance to eliminate the required parking lot, tree, landscape islands at the same meeting. And those decisions and orders were attached in the case file that you received. So here, looking at a little bit more at some of the other information as part of the case, this is the overlay district map. And then here's the statutes that we're talking about from the zoning ordinance. For the buffering and the tree islands. Here's the 300-foot radius map for the notification for the hearing, and an aerial of the subject property outlined in blue, and a fuller zoomed out map so you can see the entire property. And then the applicant provided this aerial with the subject property outlined in red. Staff did conduct a site visit of the subject property on December 12th, 2024. And here are some pictures. This is the existing building on the site. And then some other photos of the subject property. The planning director review and report regarding approval criteria, staff found that the request meets criteria 1, 2, 3, and 5, and may meet criteria 4, 6, and 7. In the event the BZA decides to approve the application, staff does recommend the following 2 conditions. Condition 1, prior to zoning permit approval, the applicant shall complete the site plan review process. And condition 2, the proposed 6-foot high fence shall be located outside the 35 feet right-of-way buffer measured from the front property line along Highway 61. So since we have a few more items on here for the other case, but I want to get to just the site plan here to show the existing conditions with the existing building, and then the demolition plan, And then here's the ultimate site layout and staking plan. You can see like a darker shaded color that would be a vehicular use area with some parking behind the existing building and a proposed additional building at the rear of the property. A grading plan, and utilities, and a landscape plan. And here's the plat, the current plat for the property. So, a lot of information. Any questions?
Wow, I turned my head and got a bunch of, I'll start with Mr. Brown.
Got a couple of questions. Hopefully a couple of questions. Thanks, sir. There we go. The previous variances, are they essentially asking for the same thing, or am I not picking up the difference?
Okay, so there is a difference, yeah. So the previous application was just to utilize the existing building. The building had been vacant for a number of years. So when they went to kind of redevelop it, I believe that it was for like an exterminator use. They had just planned to use the existing building in front and have some limited parking and a couple of parking spaces in the back that would serve their use. This is a little different because they have more parking and another building that they're proposing in the back. So because of the change in the type of use and the intensity of the site plan, they did need to come back because that was different from what was shown in 2023. Yeah.
And then just the proposed 6-foot-high fence shall be located outside of the 35-foot right-of-way buffer. Where is that on the site plan?
Right. So when we, there's a, let's see. And we were working with them to kind of, it's just right up along the,
sides,
on both sides, just right up in the front. Yeah.
Okay.
There's a regulation in the zoning ordinance limiting the height and type of fencing within that front buffer, and we just want to make sure that it complies with that part of the ordinance.
Does that answer your question, sir?
Yes, it does. Thank you.
Mr. Sedell?
Ms. Brooks, what is the use of the property? I guess that's to the south, the neighbor to the south. I'm looking at the aerial, and I can't really tell what. Looks like a lot of.
Great question.
Parking, cars parked kind of random.
Yeah, I think this apartment complex is directly, to the south. Right.
There's no housing. Is there housing up against the property line of this? In that wooded area up near the existing building on the adjacent property? Are there apartments within that?
Yeah, so there are some apartments. It looks like the driveway kind of runs parallel to the property line there. Just going to zoom out when I do this, but so it looks like this is the driveway here, and then there are some apartment units kind of clustered back here. This looks like parking that kind of loops around.
In that wooded area up in the top, up against, what is the street?
I can answer that.
Yeah.
There's about 10 buildings in that complex. They are within the trees. The apartment complex is quite wooded, so it covers most of the buildings.
Okay, that's what I thought. So in regard to the fences that you mentioned, are they running against how far do they extend? Do they extend the entire distance along where those apartments are located underneath those trees? How far does
Yeah.
the fence go?
Yeah, so we did, as part of the site plan review, recommend that they install some sort of opaque fencing to help maybe meet the spirit of the buffering for the screening, since they were asking to basically eliminate that landscaping. They agreed, and it looks, they have a fence on the plan that's shown to go down the length of the property line.
Okay.
Yeah.
Thank you. That's what I wanted to know.
Okay.
Mr. Neal?
Thank you, Mr. Chair. A couple of questions about the current structure and the new structure, and this might be for the applicant, but I'm wondering what the rules are based on this application. So the current structure had just a few parking spots, it looks like. I don't know what the use is. I lost that in the application, but the new structure is about 4,200 square feet. What are the parking requirements for that? Because if they're asking for a variance to remove buffers and parking aisles, islands, or whatever it is, I don't have any problems with any of that, but I'm wondering how many parking spots, what's dictating the number of parking spots? It looks like it's a much larger building, but is that a use thing, or what's driving that?
Yeah, so if you look on the site layout plan, there is a little chart there in the top left corner that calls out how they have calculated the parking. So the existing building is calculated off of like an office calculation, and then I believe the building to the rear, it looks like a calculation for like a warehouse type. So the office warehouse.
15 spots
They've
for the
provided.
new one?
Yeah.
We're increasing the parking, but we're asking to remove the buffers. And the solution here is we're going to add a fence all the way around it. And that way we don't have the sight lines. Is that the logic?
Well, in order to meet circulation around the building, and for lane widths and parking widths, since the property is quite narrow.
I agree, it's an unbelievable
kind of
piece of
like-
property.
They've made like a one-way to kind of, and done some angle parking to try to address that, but even with the office, they would still need some additional parking beyond what is existing at the front of the building.
The parking at the front is still staying?
Yes, yeah.
15 spots in the new drawing, that's what I was wondering. That might be a question for the applicant when they come aboard, how they're handling that. And
Yeah, so here's the parking, let's see, at the front. I think there's 3 spaces.
look like.
And then you'll circulate around one side of the building, and then there'll be some angled parking arranged kind of between the existing building and the proposed building. And then you'll circle back out around. And so that's where they're picking up most of the. Yeah.
Thank you, that's good.
Ms. Brooks, I didn't see any handicap parking on this.
It's not designated.
So that's going to be up at the front of the building. You see there's like a hatch pattern. So that would be the loading.
The trapezoid thing there.
If you zoom in on the 3 parking spots in the front, if you're looking at the building, the far left has a handicap symbol. And there's covered up with some arrows a little bit.
Thank you.
And and I believe there's
one next to the
additional
thing.
in the back here that they'll have a painted hatch mark to comply with the marking requirements for that.
That's good.
Thank you. Anyone else have any questions, staff? Does anyone else have a question of staff? Excellent job, Ms. Brooks. Excellent job. Wouldn't expect anything less. Is the applicant present?
The whole crew is.
The whole crew. So, all right, hold on. That's okay. That's okay. So I can only do one person at a time, okay? And so that first person that speaks is going to be the representative, okay? All right, go ahead. Please state your name. Okay. Pop your collar if you have to. State your name and address for the record, and please tell us why we should approve your application.
Sure. My name's Jessica Luzier. I live at 196 Wapu Road, Charleston, 29407.
Pronounce your name one more time for me.
Jessica Luzier.
Luzier.
Yes, sir.
Thank you, Miss Luzier.
No problem.
Okay.
So my husband and I own Stonecastle of Charleston. We're a small family-owned business here in West Ashley, and we want to keep it that way. We currently lease our space, and this property, as much of an eyesore as it's been to West Ashley for over 10 years now, we looked at it as a great potential spot for us. It's not an ideal location. The property is 58 feet wide, and you're right next to 526. But for us, it's a way to keep our business in West Ashley and also have the space that we need. The fencing is going to start after the existing building, and that was to try and accommodate that buffer that we're respectfully asking that we reduce, because at 58 feet wide, if you add in the buffers, you got 8 working feet, and that's just not anything to do anything with. And so we just, above the property is a vacant lot that may or may not be part of the 526 expansion, since that has changed. And below us is apartment complexes, but there are no apartment complexes that are next to our property. It's always just a green space, and then they have their roadway access. And actually, currently, right now, our current location, we back up to a neighborhood, so we're very family friendly. In the existing structure, we're going to have our showroom and our office space, and then in the warehouse, it's for us to produce our product. We make things out of cast stone, concrete, and GFRC. These are not little things. So we need the extra space to be able to manufacture these things. I think the tree island was a request because I've worked with the fire marshal hand in hand to make sure that this would be something that they can get on board with. Because of the property width, and that was to provide them plenty of turnaround space, firefighting space. But he also feels confident the fact that it's a metal building, concrete slab, and we're making things that don't combust, that we should, knock on wood, hopefully never have a fire back there. And I'm trying to think of some of the other questions that you guys asked. The parking spaces, we're working with staff to try and figure out, based upon our use space, how many parking spaces we need. And that dictated kind of how far back we had to push the warehouse to make sure it all fits in there. But we would love to take this opportunity and make something that would be enjoyable to see as you drive past on 61, and also kind of take something that has been a habitat for homeless and drug use, and address that concern too. So we've been working with the police department closely for this. So we definitely look forward to your support. This is going to be a collaborative effort because this piece of property is very challenging, but we're up for the challenge and we think it'll be a perfect fit.
Okay, great job. Thank you. Good. I'm going to let this board ask a couple questions. I just want to throw one in, 2. Tell us a little bit more of some of the things that you make. 1, how many current employees do you have now? 2, and then do you envision having more employees? 3.
Okay, you said 2.
I did, I lied.
So the first one, main products, so we make things like fireplace surrounds, we make fountains, we make chimney caps, so those actually go on the top of chimneys, so those are fairly large. And then we do things like pavers and pool copings. We've done a lot of local projects where we've done for the fallen officer. We've been part of like the Susie Jackson Memorial. We are part of the Charleston 9 Memorial, so we also are very ingrained with our community. 2 employee number. We have 10 employees, and I don't want to get any bigger. We're a family-owned business, and that's the perfect size for us. We have the perfect team. I'm not looking to go any bigger because I like the community family feel that we have.
So it is just 2 questions because you said you're not going to grow, so I did get the 2 in there, slid it in there.
And I'll throw in our hours in case you're curious about those. So 7:30 to 4:30. So we're not looking to be late. We have no weekends. So I know a lot of people are concerned about traffic on 61, as am I. So we should not be adding to that.
And some of those 10, are they family members that include you and your husband?
Just that guy.
Say again?
He's my only family in this business. Yeah.
Oh, okay, okay. He's one of the 10?
Yeah.
That's good, that's good. Okay, I'll start down here with Mr. Neal, that has a question for you.
Mr. Chair, you stole two of my questions. So very good. I only have two now. You mentioned a showroom and the warehouse. So what percentage of the parking do you think is going to be really needed for customers? That's my first question.
So we're custom projects. We're not a high volume business at
Okay.
all.
No, that's fine. That's fine. And then you mentioned storage. You're not doing anything outdoor storage or anything like that. Because I bring that up because that would be buffers, islands, and stuff like that. If you're telling me that all the products that you're making are going to be stored in the warehouse, it's not going to look like a Lowe's or a Home Depot where it's out there, then that gives me a lot more comfort level.
Yeah, I mean, that's one of the reasons why we need this, because we need the space to let things cure. But we're not like a wholesaler. We don't carry a certain stock and then people come and pick it up that we're replenishing. Everything is custom made to order. So when it's ready, it's, out the door. We're either installing it or most of the time we're installing it.
Perfect. Thank you, Mr. Chair.
Okay. Anyone else?
Can I ask?
Yes.
Do you have a showroom now?
No.
No.
And so that's part of it. We've been working with designers and builders for a while and kind of like, okay, ingrained, you're our fireplace surrounds. And then through word of mouth, they found out, wait, you do countertops too? We're like, yes. So we just kind of want a showroom where we can meet with people and also help them make decisions on the finishes, the colors, and kind of showcase. I mean, our employees are true craftsmen. It's amazing what they can do. And so we want a space where you can see that because it's a lot easier than just, I don't want to do pamphlets. This is tactile. I want to see it. I want to touch it.
Okay.
So I'm not going to hold true to those two questions. So your customers will park up front at the showroom. That's where they're going to park.
Yeah.
And then your employees will drive to the back and they'll park there. So do you have, or will you have company vehicles that will be left there overnight or anything like that?
We do currently have one work van that is left behind our gate at our current location. We're not looking to have a fleet, so that'll be all we got.
Okay, tell us about the fence that you're going to erect.
Yes, so we had talked about in lieu of buffers, because we really don't have the space, we wish we did, so a privacy fence. So I think it's 6 foot is the required. And to be honest, it would be good for security, because we've had tons of people that are still trying to camp out on our property currently.
Okay. Anyone else? Wow, okay, you must have wooed these guys. They're quiet. Are they ready to go home one?
Or they're hungry and tired, I don't know.
Well, yeah, okay. Well, thank you so very much for your testimony tonight. Do we have anyone to speak in favor? Anyone else to speak in favor? Okay.
I'll just introduce myself. I'm Laura Cabanis, and I work with JLA. So
Please state your name and address for the record.
I'm Laura Cabanis, 839 Parrot Creek Way, Charleston, South Carolina. And I work for JLA. We are the engineers on the project. So if you have any questions for us, I'm here in place of Herbert Gillum. But just want to let you know who we were.
And you do what there now?
I'm a civil engineer, so I'm actually working on the site plan design for this project.
Okay, so anything go wrong, we can blame you.
Absolutely. I've been blamed for a lot of stuff.
It won't be the first. Okay, anyone have a question for her? Thank you so very. Oh,
I'll ask.
No, go.
I'll ask one question. The traffic flow around the building, is it purposefully flipped from the ingress egress off of 61?
Purposely flipped.
Look at the arrows. You come in, you enter on the right-hand side of the property, but yet you've got access coming out on that right-hand side of the building. If you're looking at 61. There's one that I caught one of those things I noticed, and I'm just,
I see.
since you're standing there, I figured I'd ask the question.
I can look into it. I can't recall exactly
was
why
just a
we
question.
did that. It was just such a tight site. We were trying to, do everything we can to make this stuff fit and work.
Not a big deal at all.
Anyone else? Thank you so very much for your testimony tonight.
Sure.
Yes, ma'am. Anyone else to speak in favor? Anyone to speak in opposition? Anyone to speak in opposition? Very good. This case is closed to the public. Board members, do we have any? We have 2 cases now.
You want these 2 separate motions?
We gotta have 2 separate. We have to have 2 separate motions. But do we have any questions of staff regarding the first or second application? You have a
Where
question?
the trees are, I don't see the trees on the site map that we're asking to remove.
There aren't any to be, well, there,
8 and 9, right?
no, it was just to
Case 9 had 2 trees, right?
We're on
Or
the
7 and 8. 7 and 8. Case 7 and 8.
7, 8, I'm sorry, I'm thinking the wrong thing. Yeah, I'm fine.
Okay. So, any more questions of staff? Any more general discussion on either application? Okay. So, with that being said, can I have a motion to either approve or deny either application?
Can
I'll
I
make a motion.
Sorry to bring this up. I'm going through this. I did realize there was one comment in opposition. It was part of your packet. I didn't want to mention that on the record.
Yeah, I saw. Okay. I did see it, and thank you for recognizing it. But we're going to move forward with the motion. Yes, sir.
Mr. Chairman, I move that we approve BZA variance request 1124-00825. This is the one to reduce the required buffers on the property. I find that there are exceptional conditions pertaining to this property. It's extremely narrow, and in order to utilize the property, we heard testimony that if we maintain buffers, we would be left with 8 feet. There's not much you can do commercially with 8 feet, and that's understandable. Conditions do not apply to other property in the vicinity. This is a very unusual lot. I think I've never seen one quite that long and such narrow. But certainly, if we look at the area map, there are no properties similar to this. So it meets that criteria. Unnecessary prohibits to restrict the use of the property. I think we've heard testimony that the buffers need to be not considered because of the fire, emergency vehicle, need room to do turnarounds and parking required to meet the needs of both the warehouse and the showroom. The variance will not substantially do a detriment to the adjacent property or the public good. We've heard testimony that there will be fences the length of the property to protect the property to the south, which is an apartment complex, with a fence, privacy fence, and then to the north, which is undeveloped at this time. It will not extend to use that is not permitted in the zoning district, so it meets that criteria. And the variance is not the result of the applicant's actions. They're trying to utilize for an abandoned property that has been an eyesore for the community for many years. And finally, it will not substantially conflict with the comprehensive plan. It meets that criteria. So I move that this be approved along with the 2 conditions that are cited by staff.
Second.
All right, we have a motion that's properly moved in second. Any discussion on this application 00825? All those in favor, please indicate by saying aye and raising your right hand. Aye. Are any opposed? Okay, aye. That carries. So on 826.
Yeah. Mr. Chairman, I move that we approve the variance request for BZA 1124-00826 to eliminate the requirement for islands within the parking area. Similar to the previous case, there's extraordinary exception conditions, the size and narrowness of the lot, the need to make available area for emergency vehicles to turn around and so forth. The conditions don't apply. There are no other properties of similar size in the area. To require these island trees would prohibit the use of the property, especially for emergency situations. The variance will not be a substantial detriment to the adjacent properties. We heard that because there'll be fences to protect, or not protect, but prevent viewing of a parking area with no islands of trees. It will not establish a use not permitted in the zoning district and is not the result of the applicant's actions. It's just because of the narrowness of the lot and to utilize it as a commercial property. And finally, it will not conflict with a comprehensive plan.
Second. Along with the two criteria?
And the two criteria, my apologies,
Very
yes.
good. Very good. All right. So, any discussion? We have an application that has been properly moved and second. All those in favor, please indicate by saying aye and raise your right hand.
Aye.
Same, okay, it is unanimous. Well, hot diggity, you got, you got two applications that have been approved. Within 10 days, you'll be getting information from staff letting you know the next steps in the process. You did an absolutely wonderful job. Congratulations to all four of you. And I hope that you have a wonderful and great evening as well. Okay, we're down here almost to the finish line. Our next case is case BZA 1124-00827. And Ms. Brooks will be administering that application. We're cleaning the room out, guys, I tell you.
Not much left.
The applicant, Chris Orman of Pavilion Development Company, and the property owners, Kenneth Smalls and Ernest Kinlock, are requesting a variance to remove 2 grand trees for a proposed vehicle service use at 3675 Savannah Highway, TMS 28500000018 in the St. Andrews area of Charleston County. More specifically, the applicant is requesting to remove a 24.5-inch diameter breast height Grand Southern Red Oak tree and a 28-inch Grand Southern Red Oak tree. The subject property and properties to the east and south are in the industrial IN zoning district here in the purple color. The adjacent property to the north and west are in the City of Charleston's jurisdiction in the gray hatch. The 0.95 acre property is currently vacant. The applicant is proposing to construct a 1,500 square foot 3-bay drive-through oil change building, Take 5 oil change. The project is currently going through the site plan review process, ZSPR 0924-01066. The representative for the project is Jessica Myers, PE of C. Baker Engineering. The applicant's letter of intent explains, quote, "We are requesting a variance from the Charleston County zoning ordinance for the removal of 2 grand trees located on TMS 28500000018. The trees proposed for removal are a 24.5-inch red oak, tree number 73, and a 28-inch red oak, tree number 107. Both trees have been evaluated by a third-party arborist, and the county's arborists have both been classified as a grade C, which corresponds to a fair rating. Please refer to the provided BZA exhibits for more information and detail," end quote. As part of the case information, here's the tree protection and preservation ordinance. Here is the 300-foot radius map for notification of the project or the case. Aerial photograph zoomed in, outlined subject property outlined in blue, and zoom out. Staff conducted a site visit also on December 12th, 2024. Some pictures of the subject property. Here's the 24.5-inch DBH Southern Red Oak and the 28-inch Red Oak requested. and a couple other pictures of the subject property. Here's a site plan of the subject property. Here you'll see the building, and then I'll have to confirm what color the variance trees are. I'll do that. It looks like, I think the ones in yellow are the ones, the color requested here with the red X's. Some other information for the site plan review. Here's the landscape plan proposed and the current plat of the property. For the variance approval criteria, staff has found the requests may meet criteria 1, 2, 3, 4, 6, and 7, and meets criteria 5. In the event the board decides to approve the request, staff does recommend the following conditions. Condition 1, prior to zoning permit approval, the applicant shall complete the site plan review process. Condition 2, the applicant shall mitigate the removal of 52 inches, DBH inches, by either A, submitting a mitigation plan for review and approval indicating the installation of canopy trees no smaller than 2 1/2 inches in caliber, equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 9.2.6 of the Charleston County Zoning and Land Development Regulations. Or C, a combination of both A and B. The allotted mitigation shall be in place prior to removal. Condition 3, tree barricades shall be constructed of chain link fencing and installed around all protected trees within 40 feet of disturbance prior to any construction pursuant to section 9.2.4 of the Charleston County Zoning and Land Development Regulations. And condition 4, the applicant shall retain a certified arborist to monitor and treat all grand trees within 40 feet of disturbance through the duration of construction. The applicant shall provide a copy of the tree preservation plan to the zoning staff for review and approval prior to zoning permit approval for construction. That's a staff review. Are there any questions?
Any questions of staff? Anyone? Thank you again, Ms. Brooks.
Thank you.
Come on forward. Please state your name and address for the record, and please tell us why we should approve this application.
Good evening. My name is Jessica Myers. My address is P.O. Box 81082, Charleston, South Carolina, 29416. I am the engineer of record for the project, representing C. Baker. With me tonight, I also have the development manager, Mr. Chris Orman, if y'all have any specific questions to operations or the company itself. As Ms. Brooks stated, we are requesting a variance to remove 2 of 4 grand trees on site. We have made many efforts to look at all site plan options that are available to us. We have made an effort to preserve the healthiest of the trees on site. Those were the trees shown in blue. Those were grade B. We're proposing to remove the grade Cs. We also have one of those long, narrow parcels, so it's got a unique challenge in its configuration. We've been working closely with county staff as well as DOT staff since both Savannah Highway and Old Charleston Road are DOT maintained. This site poses another unique challenge in that DOT is unable to grant us full access from Savannah Highway. So the only way we can achieve full access, meaning both right turns, left turns, in and out of the property, would be from Old Charleston Road. And that's the purpose that we're requesting to remove the 24.5-inch oak tree. Additionally, we did reach out to the adjacent property owner to the Plan West to see if they would be amenable to doing a shared access drive. That would have made DOT more comfortable providing a full access driveway. It also would have reduced some of the narrow constraint of the site. However, the adjacent property owner was not amenable. one last challenge the site has is it is located within a special protection area as defined by the Charleston County's Stormwater Department. So we are subject to more stringent design regulations as it comes to stormwater. I'll spare you the details, but essentially we need a little extra room to maintain stormwater on site. So with those things in mind and the efforts that we've taken to mitigate some of these challenges, we would ask the board for approval to remove these 2 grand trees. I'm happy to answer any questions y'all have.
Very good. You were here nice and early. You beat me here today. What owner would not allow you to use their entrance or work with you?
We had reached out to the owner of TMS 137.
Which one is that?
That is, if you're looking at the plan, just to the left. The one with the small building on it.
Okay, to your left. So the one at the very top, the long?
Yes, it's another one of the long
Okay,
skinny
okay.
parcels that
Okay.
goes all the way through. Yes, sir.
Okay. What kind of business is that, or what kind of building is that? Do you know? Recall?
It's an old church building. It's currently not being used at this time.
Okay, I drove by that this morning. Tell me about your retention, your water retention pond that you have there. I know it's very long. Speak to me. I know you didn't want to, but then
Happy to do it. I just don't want to put you to sleep any more than you already
won't.
have. So with the county's special protection area, we are required to reduce, not just meet, we're required to reduce the amount of runoff coming off site. And this is in an effort in flood prone areas and just in an effort that the county is leading to mitigate stormwater impacts. Because this site is so close to the marsh, we're at a very low elevation. I think we're down at about approximately elevation 4 or 5 at our outfall point of the site. We're very limited in what we can do in terms of depth storage without bringing in a ton of fill on site that could potentially negatively impact the neighbors. So we've had to expand horizontally instead of vertically to achieve the required volume necessary for stormwater maintenance.
Okay. Have they purchased the property, or is it still under contract?
I believe this property is still under contract.
Okay, that's what I thought. And also tell me a little bit, I'm not trying to steal any questions over here, but tell me about your parking situation. I see that you have at least, what is it, 5 parking spots, or is it 6?
6.
6.
Including the ADA.
Correct. So the whole concept is that you have a client that would come in, they really wouldn't park out there. So all the parking that you have there is just for the employees, correct?
That is correct. And perhaps Ms. Brooks will be able to address this, but I believe the parking requirement was based on the number of bays, the number of service bays.
Okay.
But you are correct that the intent with this being a drive-through oil service is that patrons would come and drive through the building. So the parking shown would ultimately just be for the employees, which I believe are about 3 at any given time.
Okay. So there's no room for staging of vehicles waiting to be serviced, then? Or there would be no vehicles left there for the next day, or company vehicles left on the premises?
No company vehicles that I'm aware of. Vehicle staging is included in the maneuverability area going into the bays.
So they would park on the side? Queue?
Queuing, not
Queuing.
parking.
Okay, queuing. So they just remain in their cars until it's time
That's
for them
correct.
to come in?
Yes.
Okay. That's my questions. Well, tell us about the trees, too.
Well, I had the pleasure of traversing the site with the county's arborist. We started out with a third-party arborist review, and at the recommendation of the county, we walked the site with their professional, who generally concurred with most of the ratings. In fact, he was able to help us out with one of the trees that, in fact, was not grand. So very informative. He did concur with the C gradings, which I believe corresponds to a fair rating. Again, all 4 grand trees on site are all of the southern red oak species, so at least we have some consistency there. As I stated previously, we did our best to preserve and design around the healthiest of those trees, the ones that had the biggest chance of flourishing after development.
Okay. Good? Any questions of staff? Any other board members, you have any questions? Thank you so very much for your testimony.
Thank you very much for your time and your patience tonight.
Yes. Do we have anyone else to speak in favor of this application? Okay. Please state your name and address for the record, and please tell us why we should approve this application, sir.
Chris Orman, 1195 Lee Boulevard, Orangeburg, South Carolina, 29118.
Orangeburg. Oh, okay. From
Yes,
my
sir.
neck of the woods. Okay, come on in.
No, I'm developer on behalf of this project, but just, we've had a lot of success developing for Take 5. Charleston itself has put Take 5, this franchise in particular, into becoming the #1 franchise in the state and across the country. And, I think they're up to 20 stores. They typically employ 15 people at each place. They're excited about this location, and Charleston's been great to them and the whole MSA, and looking forward to hopefully getting one here.
Okay, good. You kind of piqued my interest there. One of the fastest growing businesses. That's great. So what do you do with Take 5? You just build these sites as you go around?
Yes, sir.
Or are you a part of the franchise corporation?
No, I'm just the developer for them.
You're just a developer. Okay. Okay. All right.
Thank you.
Thank you so very much. Wait a minute, I'm sorry. We have a question for you.
You mentioned 15 employees, and then we were looking at the amount of parking is for how many?
They'll employ 15 at a location, but there would be 3 to 4 there only at a time.
Does it shift work? Is
Yes.
that- okay, thank you.
Thank you.
Anyone else? Thank you. Anyone else to speak in favor of this application? Anyone to speak in opposition? Anyone to speak in opposition? Very good. The case is closed to the public. Board members, do we have any questions of staff?
I'll take it.
All right, Mr. Neal.
Thank you, Mr. Chair. In case BZA 1124000827, I make a motion to approve the variance request to remove 2 grand trees for the application. I see in a very well put together application. I have no problems. I think that they meet all 7 of the criteria. Number 1, there are extraordinary exceptional conditions pertaining to this particular piece of property. Again, another property that is just really, really hard to develop, but I applaud the applicant for putting it together on this very narrow piece of property. Condition number 2, these conditions do not generally apply to the property in the vicinity. Again, this is a very unique property, but they're still going to be able to develop it and do it with good taste here. So I don't have any problems with number 2. Number 3, because of the conditions, the application of this ordinance to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property. The applicant has said testimony here that they tried to alter their entrance plan, but were not successful working with their neighbors. So I applaud them for going out of their way to try to reduce the number of trees in the variance application, but they were not successful. But it will still not change this piece of property or anything around it, the utilization of it. Number 4, the authorization of a variance will not be substantial detriment to the adjacent property or to the public good, and the character of the zoning district will not be harmed by the granting of the variance. Again, they're trying to work with their neighbors. They're trying to make this thing work the best as possible, and they reduce their initial variance application from 4 to 2, it looks like, because of the trees, and the 2 trees that they're going to remove are of C grade. Variance criteria number 5, the Board of Zoning Appeals shall not grant a variance that affect what would allow the establishment of a use not otherwise permitted in the zoning district. everything is fine here. Everything applies. There's no extraordinary issue that they'll be changing the overall character here. So it meets number 5. Number 6, the need for the variance is not the result of the applicant's own actions. Actually, they actually tried to change this to make it better so they could reduce the number of trees that were being impacted here. So it definitely meets criteria number 6. Number 7, the granting of the variance does not substantially conflict with a comprehensive plan for this ordinance. So I think it meets all 7. Were there staff conditions on this one? 4 additional staff conditions, so I would like to include those in my motion that they meet all 4 of the staff recommendations.
I second it. All right. I'll second it this time. Just throw my name in the hat. Any discussion? Very good. All those in favor, please indicate by saying aye and raise your right hand. Aye. It is unanimous. Very good. Your application has been approved. Within 10 working days, you'll be getting information from our staff letting you know the next steps in the process. Once again, congratulations and good night. All right, we're down to the tail end. Ms. Brooks. Whew.
Last case.
Yes,
Yep.
last case. BZA 11-24-00828.
All right, the applicant and property owners, William and Mary Ann I'm not saying, I'm not gonna say this right. Rodno. Okay, I'm sorry for that. Are requesting a variance to remove a 40-inch diameter breast height DBH codominant stem grand live oak tree for a proposed 27.3 feet by 65 feet, single-family residence at 1636 Turns Nest Road, TMS 331-0700072 on James Island in Charleston County. The subject property and surrounding properties are located in the low-density manufactured housing subdivision, MHS zoning district. And you can see that here, it's the yellow hatch on the map. The 0.22 acre property contains a 25.6 feet by 66.2 feet residence. The applicant and property owners are proposing to remove the current home and replace it with an elevated 27.3 feet by 65 feet home that will be constructed to an AE11 flood zone standard. Here is a copy of the Tree Protection and Preservation Ordinance. Here is the 300-foot radius map with the notification properties outlined in blue. Here is the subject property, a zoom-in aerial outlined in blue and zoomed out. The county staff, zoning staff, did conduct a site visit of the subject property on December 12th, 2024. Here are some pictures from the site visit. The 40-inch codominant stem grand live oak tree, and some other pictures of the existing conditions on the property. Here's the site plan survey for the existing home. I think this is the proposed. Here we go. Here's the proposed, and you can see the outlines of the tree protection areas here and the kind of like yellowed circles. And the plat of the property starred here in blue. Okay. So as far as the variance approval criteria, staff found that the application may meet criteria 4, 6, and 7, and does meet criteria 1, 2, 3, and 5. In the event the board does decide to approve the application, staff recommends one condition: the applicant shall mitigate the removal of the 40-inch DBH live oak tree by either A, submitting a mitigation plan for review and approval, indicating the installation of canopy trees no smaller than 2 1/2 inches in caliper equaling inch per inch replacement. B, by depositing funds into the Charleston County Tree Fund as described in section 9.6.2 of the Charleston County Zoning and Land Development Regulations. Or C, a combination of both A and B. The allotted mitigation shall be in place prior to removal of the tree. Any questions of staff?
Any questions? Any questions?
I just have one. What's the grade of the tree that's being removed?
It's a B-grade tree. Yes.
What type was it? It was
It's a southern live oak.
oak.
Yep. No.
All righty. Anyone else? Thank you again, Ms. Brooks.
Okay, yeah, and they do have the site plan, they do have kind of one that's, you can see the shade, the lighter shade of the existing footprint and the darker shade of the proposed footprint on the tree label site plan, so if that's helpful.
I'm just looking at the plan and trying to figure out, if they mitigate it and put trees in there, where they're gonna put them.
Yeah.
But that's
Right.
not a question for me. That's above my pay grade.
Can I ask a follow-up question?
Yes, you may.
What is the cost of mitigation should they replace the trees in this situation?
Yeah. So, currently we require some, in an effort to be as fair as possible, at least 2 quotes for current, value of planted trees. I imagine that would probably fall around per inch, probably fall around $200, $250 per inch, so.
Dollar-wise, what's it?
Times 24 inch of the tree.
So
4 times 200.
that would be approximately $8,000. Approximate, depends on market value.
The way I'm reading the recommendation, they've got to, if they were going to plant trees, they're going to have to pay for them before they cut. And I'm mindful of the City of Canton case. If they chose to appeal whatever the mitigation is, they'd already be out of the money. I'm wondering whether in this unique case, as we've done in others, whether we ought to require mitigation under these unique circumstances.
Sure, and you have the authority to kind of like,
It's a condition that's on it, so you can.
Because if they
make
came back,
whatever
and
you
if they came,
think is
They
appropriate.
could come back and appeal to us if they weren't satisfied, but they would have already paid the money. The applicant has.
Very good. Thank you, Ms. Brooks. Is the applicant present? There.
No one's left.
Oh, well, no, let's go. Good evening. Please state your name and address for the record, and please tell us why we should approve your application.
Thank you for your patience in this process. Long night. I'm Mary Ann Ridenauer, and my husband and I live at 1636 Turns Nest Road in Charleston on James Island.
Pronounce your name one last time.
Mary Ann Ridenauer. Ridenauer.
Good. I just want to get it right. Okay, thank you.
It's fine. People mess it up. So we've lived in this house about 9 years with the hope and the prayer that one day we would be able to take down the double wide that we live in. It's in pretty poor condition. To build a safe and stable home as we enter towards our retirement years. This tree is growing over the house now. And we've already had roof damage during storms that resulted in water damage that accelerated the deterioration of the home. And so to build a new home, we need to elevate it anyway. And so that's why we're here asking for this tree, just this one. We have others on the property, but it's not a big piece of property. The footprint of the house we plan to put up is pretty much the same as we have now, but we just need to do something about this one tree.
Easy enough. Any questions of this applicant? Yes, sir.
As I understand it, you're going to build up, which also necessitates a need to move this tree.
Correct, because the house we're in is so old, it's not elevated high enough to whatever the new standards are, so we need to elevate the new. So, yeah, we're just basically replacing kind of the footprint of the home we have with a better built home, just we have to raise it.
I have a question for you. So I'm looking at the aerial photo, not the aerial photo, but just the photo that we have of your home, your lot. You have a corner lot, Turn's Nest and Wild Wing. Not that one. Not that one. Well, yeah, well, that was, no, is that the right one? Yeah, it is. Okay. Yeah, I'm looking at that one.
Okay.
There is enough room for you to put more trees in there, isn't it?
I don't know,
To
to
plant
tell you the
trees.
truth.
Yeah.
We have, in the front of the house, we have 6 crepe myrtles? We have 6 crepe myrtles that are kind of immature that we put in along the front. And I really don't know what the rules are about how far you can go towards the street and the setbacks and things like that. So you would have to tell us if we
Oh,
have
we
room
have
for-
somebody that's an expert to tell us.
if we have any room for trees.
Okay.
I would just say that some of the property adjacent to the street on both sides is probably reserved for the county. So their lot does not extend to the street.
Correct. Correct. Any suggestion, Mr. Foster?
This is going to be a scenario where she would have to pay and plant. There's not much room for more trees. The back of her lot is heavily wooded. So I don't know if that GIS picture shows what's there now. There are more trees planted there, crepe myrtles than what that shows. There's not much more room to plant trees on that property.
Is what I was thinking.
Can we dispense with the requirement in this case, in this unique case, to require mitigation? Do we have that authority?
Yes.
Yes, you can adjust it however you see appropriate. We just make a recommendation that's a general recommendation for every case, and then, but you could change that.
Just so the board knows, there have been cases in the past, a few years ago, where one of the board members proposed no financial mitigation. So it's been 0 to whatever the statute requires. No, that was before you became a board member.
Yes, sir. Do you have a question of her?
No, I have a procedural question.
Okay, so let me come back to you.
Yeah, you're right. I agree.
Thank you so very much for your testimony today. Just hold that thought. Do we have anyone else that wants to speak in favor of this application? Do we have anyone to speak in favor? Do we have anyone to speak in opposition? Do we have anyone to speak in opposition? Very good. The case is closed to the public. You had a question.
So procedural wise, if we pass a proposal tonight that is in line with the ordinance of mitigation, and then they come out and find out that they can put so many trees out there, but they're still going to put it to the bank, they can come back to this board and apply for a reduction of our original findings of saying what the mitigation is. We don't have to create something new right here just to come up out of there when the applicant hasn't proposed that they don't know what they want to do yet. So I think we're putting the cart before the horse by trying to come up with a mitigation plan that's not in line with what is in the ordinance, is how I feel. Now, I know that we have voted for no mitigation and make them do trees or money, and that's what the tree bank is, but I just think we're early. Let them come in and come up with what needs to be done like we would normally do, and then if we think it's excessive, they can come back under some statute, I'd imagine, to apply. Or does it go to the zoning administrator or something like that?
For your decisions, they have 30 days to appeal. So they would be limited in the amount of time they have to appeal your decision, the board's decision.
So we would be in effect forcing them to incur an additional cost associated with appeal, further delay. And this also provides that the allotted mitigation should be in place prior to removal. I think they're going to improve. I just don't think having them incur an extra $8,000 in addition to cutting down the trees.
Like Mr. Hughes just said, this is a quasi-judicial body. Whomever makes a motion can make a motion however, with the conditions. And if the general board doesn't have that agreement, then we can vote it down or make changes to it. So, it's however you structure the approval or denial. Okay, yeah, there's several ways you can look at it. Mr. Brown?
I just want to understand, so if we don't change anything and say they have to put into the bank and just go with what the current ordinance says, then if they want to not pay or pay
Those are
less,
conditions.
right, then they would have to appeal our decision? Or is it a separate thing for them to come back?
So the process is, once the board makes a decision, the applicant has 30 days to appeal that decision, whatever part of the decision they want. But so essentially, it would be too late for them to come back after they've done the project to appeal the decision.
Okay.
Is that clear as mud?
Clear as mud.
Clear as mud? That's fun, isn't it? Okay. Any more questions of staff?
I do.
Yes, sir.
So in a previous decision, this board has made to reduce a mitigation because they thought there was enough trees or something there. I believe at least the last one, and I know each case stands on their own and we're not comparing, but for that vote, the applicant made the request that they were not financially able to pay the $8,000 or $10,000 because there was a tree out in Mount Pleasant. And in this application is not part of, they're not asking for that, is the only point I'm making.
Sure, and just for clarification, I'm not referring to this, this makeup of the board. I'm actually referring to, I believe the only person remaining is Mr. Ray, from a previous board member who often, I'll just say that board member disliked the mitigation.
Right. No, I understand that.
I have to say his name. Mr. Goldstein, Mr. Goldstein, Mr. Goldstein. I know you don't like to see that. I know you didn't see it. That's a good colleague of ours. Oh, I love him. He's good people.
I mean, just for, because it's my job to give the board direction, you can amend the way this is worded.
Right.
So that if you choose to give the applicant a way to avoid the costs, you can actually amend the way this recommendation is written to give them that potential relief.
That's the way you do it.
That was said so eloquently.
Yeah.
Now, any other questions of staff?
I ain't making a motion now.
Okay. So, all right, so at this time, like I said, the case is closed to the public. At this time, I need a motion either to approve or deny this last case for us tonight. That would be you, sir?
I would be glad to make a motion to approve the request for a variance in this case. Notice has been given, jurisdiction is proper. This matter is governed by Zelda Chapter 9, in particular, specifically 9.2. All the criteria of 3.10.6, 1 through 7 have been met. I'm mindful of this being in a low-lying area with potential for flooding. They want to replace the home with one of a higher elevation. Trees are already going over the property and impacting on the roof and has already done damage. The only reasonable alternative in this case is to allow the applicant, under these unique circumstances, to be able to cut these trees. Thus, there are extraordinary and exceptional circumstances. This doesn't apply to, and I'm going fast, but we know where we're going. These conditions don't apply to other properties. These are by statute. I've got to recite these findings. The application, because of these conditions and the application of this ordinance to this particular piece of property would effectively prohibit them or unreasonably restrict them from having a reasonable house to replace what they've had. They've followed the correct procedure. Under Section 4, the authorization of a variance will not be a substantial detriment to adjacent properties or the public good. In fact, it'll be for the public good and for them, and it's within the policies of the county to allow them to have housing under these circumstances. and it's, again, consistent with the county policy. We're not granting the variance to allow a use that's not permitted. It clearly meets this criteria. The need for the variance is not the result of the applicant's own actions. And using golf terms, it's kind of the lay of the land where it is. Excuse the pun, but they need help. The granting of the variance does not substantially conflict with the comprehensive plan or the purposes of the ordinance. Now, under what I've been struggling with under the seminal case in the country is the city of Canton lawsuit where Canton wanted to require mitigation, and the courts ultimately determined that the homeowner was correct and unfortunately cost the government a lot of money for not acting in a more reasoned fashion. So I wouldn't require mitigation under these circumstances. I'm mindful of the need to mitigate, and I can look at these two fine people and I imagine that they're going to find it in their hearts to plant a tree or two somewhere, and I can see them nodding. So I wouldn't require mitigation under these circumstances. We've not done it in the past, and it seems no need to do it here. That just seems fair to me. So that's my motion. Second.
Point of clarity. So you're looking to remove the special condition 1 altogether, or part A, B, or C?
I wouldn't impose the recommendations of the conditions that are proposed on this couple under this unique circumstances. I would eliminate it. I think in good faith, I could already seen them nod that they're going to find it in their hearts to plant some trees somewhere. We just don't know what. So I wouldn't require it. I would eliminate that. Be done with it.
That's his motion.
But I want to understand, so you're not...
Mitigation.
He's made the motion and eliminated mitigation.
Okay. So everybody understand that?
Yeah.
Okay. Did we get a second? Okay, so
Discussion. Yeah, I would ask if they consider, I want to help these folks too. The trees have been growing on the house, but I think zero mitigation without them asking in the application for it, I would say do 50% or do some type of look back and give them the ability to come back in 90 days and ask for a certain thing instead of just giving them a blanket, no mitigation. That's just how I feel. I'm going to vote against the motion if that is included. But there's 6 of us here, and there's plenty, and I vote in the minority all the time, and it has nothing to do against this group. I just think we're asking for something that no one's asked for. That's just my opinion.
we're in discussion. Go ahead.
Just to get clarification on when we make a motion, or if this is approved to not require mitigation, it's just a one-time thing, right? It doesn't.
It's just-
establish
it
any sort of
It doesn't set a precedent.
Yeah, there's no precedent.
Any other discussion? I do agree with you, Mr. Neal.
I just want to clarify Mr. Chulo's statement about the good people on their own potentially planting trees. That is not an obligation.
Yeah.
Correct. That's not an obligation. I just make that observation. We didn't require it in another case. I wouldn't require it in this unique case for the reasons I've stated. So I stand by my motion and have a second.
Would you reconsider and do a maybe half?
I wouldn't require mitigation under these circumstances for another case.
I think-
And I'm mindful of the Canton case as well, and the impact would be de minimis, and it would be disproportionate to the benefit.
And we're having discussion, right?
Yes, sir.
So if we heard testimony that the tree has caused extensive damage to the house that's there. So if they build a new house, the tree is still there, then the damage that's been inflicted on the existing house will now take place on the new house. So, and we all saw the photographs, this tree hangs over an entire house. So I think I'm sorry, what was the type of tree? Live oak. A live oak tree. So it would seem to me that this is very reasonable. I'm surprised they didn't just argue to move the tree because it's damaging their house. We've had cases like that in the past.
So the application is to remove that tree?
Yes.
Okay. And
But I'm just making the point, they didn't ask because it would damage the new home, but I think it's damaging the existing home. The new home is going to the exact same place. We heard testimony of that. So I think it's a logical assumption that the tree would then damage the new home, which is going in the exact same location.
True. Just for clarification, I think what the board is discussing is what mitigation, if any. I think everyone is on an agreement with removing the tree. The issue is, what are you all doing about the mitigation, if any?
Just, I think an argument, I don't know if it's an argument's the right term to use, but it sounds like they have most likely lost at least the amount of what would be required by mitigation at this point.
I can't hear you.
I'm saying I think that they have probably already lost a dollar figure or amount because they're having to, fix and repair, and now making the choice to replace the entire house through the cause of this tree. So I was kind of hearing what you had to say, and now I kind of wonder, they maybe have already lost the amount that they would be required to pay in the mitigation, so.
May I follow? Mr. Chair, I agree, and again, I am listening and I'm hearing every argument. My only issue is mitigation is not just for the folks that are here. Mitigation also funds the tree bank for the county. That's where they use those funds to put trees in other areas. So that's why the ordinance put in place. Like I said, there's other issues here for the tree bank. So that's what funds a lot of projects. So whatever y'all decide, it's fine. I'll vote the way it is.
All right, I'll call for the question. We'll talk about this all day. All those in favor, please indicate by saying aye and raise your right hand. Okay, and all those opposed, which we do, but
Nope.
it's still, okay, you said it. All right, but it still carries. All right, congratulations. Your application has been approved, and in 10 days, you'll be getting information from staff letting you know the next steps in the process. Congratulations, and good night. God, we did it in 3 hours. Easy, that was 4. So, do you have anything for us?
Looks like next meeting, 6 cases. 4 of the cases are short-term rental applications. And got 2 new members here. Happy for that. And here's some information on, we started a new year, so we have to get trained again.
Yep.
So here's the ongoing training. The new members will do an orientation, and the existing members will do a 3-hour.
And just next Monday at our planning commission meeting, we're giving them an hour and a half of training. If you are interested, you are welcome to come to that meeting at 2:00 if you would also like an hour and a half of your training.
So that would count?
Yes. Mhm.
Okay, that's
Yep.
next Monday?
That is next Monday at 2:00 here. Yeah. It's our planning commission meeting, and they don't have any cases, so we're going to just give them an hour and a half of their training. So if you are interested, I can't even remember what the title of that one is. I'll find out. We'll send it to you. Yeah.
But you don't have.
We had, Mr. Hughes, you had a question?
Because I'm new.
There you go.
I like to learn.
Okay. Make always go live.
Yeah.
No, I want to speak to the board.
Oh, okay.
Don't want to speak to the public.
All right, yeah, if you adjourn it.
Okay, yep. So I just do want to say this time, welcome our 2 new board members. Glad to have you here. And look forward to a fruitful 4 years with you. And meeting's adjourned. Go ahead.
So just one observation. The gentleman who is building the house, you have to.
I can't hear you.